Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
In this case. Now, again, I don't want to muddy the waters on the statement, just this one first. In looking at kind of the timeline here, we go all the way back to where I first came in the case on November 9th of 2022.
All right, I was hoping to have a little soundbite there with Judge Newman just for old time's sake, but it seems like he's not participating. We're hearing some argument in his case. Judge Newman just dismissed the jury for the day in the hot car case. He said, we're not going to need you today. Go home. We'll see you tomorrow.
Our Supreme Court issued a general sessions docket.
We'll cut out of that one just a little bit. There, bring the jury. There's Judge Newman. Appreciate that. Welcome to the Court of Public Opinion. I am the recovery addict. Thank you very much for being here today. We just got bad news right before that as well. So it looks like the case is not really going forward. They're doing some pretrial motions. It's where they're arguing in Brandy's case. So that one's not going with the jury. They're not starting with opening statements yet. The case that I was about to follow, the initial word was that we were going to have a live stream available for us, and the court just confirmed to me that actually we're not going to do that. I'm like, well, thanks. Better late than never. But at least we know, a few minutes ahead of time. Thanks, Wisconsin. Ivan, I'm blaming you for that one. Because why not, right? All right, so we're gonna have to look around and see what's available. We might do a little bit of court hopping in Wisconsin if we can find any court that still wants to live stream. I was looking actually to see if we could, visit some of the judges that we've seen in the past that we really enjoyed. And so I started with, the very beginning with Judge Doro, and I went through her docket, and I was looking at all the cases she has, and I don't know if Daryl Brooks was just the last one she wanted to handle. She's like, look, I'm done with criminal trials. But all she has on her docket for like the next months is divorce. She's doing family court. That's it. She's like, I'm done with these soft sits. Give me a good old divorce case any day. So those typically are not televised either. But anyway, that's going on. Let's see. The one we were going to watch in Wisconsin was with Judge McNamara out of Branch 5, the state versus Justin M. Reedy. It was an interesting little DUI trial where the guy wants a 12-person jury to prove that the officer was wrong and he's not as think as you drunk I am. So I thought that would be a little bit of fun. We hadn't watched a DUI trial before, and it turns out the court says no on that one. So bummer on that front, but we might do a little court hopping and see if we can find some action somewhere else as well. I do have to do a couple things. And most of them are not working. Let's see. I need this button. Okay, right there. That was this. Oh, wait. I can't put that one up first. I completely missed who's first in chat. Was it Kim R? Kim R, was that who was first in chat? I've lost it here. I think it's Kim R. I've got my fingers crossed. I tried to watch and see who was first. Let's see. Paula Mack, I did not see the burner phone. I did not see you sent me a burner phone message. Let me update. Oh, it's just updated right now. Now I get them. The TikTok one. Let's see. First of all, Paul, I'm going to follow you back on TikTok. I'm not seeing it. I'm not seeing it yet. That goes to some hospital room video. Oh, wait. Okay, wait. Let's see. See if I can open this through Facebook. I'm not liking it. We'll have to check. Well, I'll look. I want to see if I can find that video. That's good. I think it's Kim. Kim, congratulations. I'm going to award it to you anyway. If it wasn't you, sometimes wrong people get convicted. Just know that, the justice system is not perfect. And in this case, you might be held accountable for something somebody else did. And hey, it happens. You file an appeal. What are you going to do?
How did you do that?
Topless Tuesday. I didn't realize that was a thing. Topless Tuesday goes with Passion Pantsless Friday. I guess the two go together. Okay. Jury's supposed to be back tomorrow at 9:30 a.m. is what I heard. Tomorrow. They got released for the day and said come back tomorrow. I thought it was for the day.
Don't miss the forest for the trees.
I might be wrong on that. Did somebody else here? We should watch Newman. I can bring him on really quickly. We can take a look at what's going on, but I'm pretty sure that trial's. It's got awesome potato microphone audio.
Given under what's here, and I hate to pound the chest a bit, but I think there has to be sending a message that the whole purpose of timely disclosure of evidence means something. And having this is a tactic that puts defense counsel at a disadvantage and impairs the defendant's right to a fair trial or right to present a meaningful opportunity having meaningful opportunity to present a full and complete defense. And that certainly violates the 5th, 6th, 14th Amendments.
They've been arguing that the notice was insufficient
Sections 3 and 10,
regarding conspiracy this morning.
Morning. South Carolina Constitution. It's just fundamentally unfair to have
That got ruled down.
provided in this manner, specifically when there's no reports given and given the just over dilatory amount of time provided. And I'll take it piece by piece, but that's the first set.
Piece by piece on the same issue?
So we have multiple different issues related to discovery, but for the JED, I figured it's easier for the record, easier for Your Honor if we take it by evidence.
All right.
Thank you.
Anything you have to say on that, Mr.
Is this yesterday's video then? Am I watching yesterday's video?
All right.
I might be watching yesterday's
response
video.
by the state.
Okay. Let me just double check. Yeah, I'm watching an old video. That's why. So that's no good.
When
No
I
good deed
provided
goes unpunished.
something I'm not required to provide. Obviously, under Rule 5, I don't have to.
Okay, so we're going to skip that because that was yesterday's court. I got mixed up on that one. That's what happened when I do an old search on the internet. I get the old information. Let's see. Yeah, today, if we look today, it's just right there. So we don't have anything out of the court yet. Let's see. They're going to start at 9:30, so they got a few minutes. It's going to start. They had motions yesterday after jury was selected. He released the jury on 4 and had motions. Okay, so I was watching the old stuff. I'm living in the past, memories, good memories. Judge Newman is great, is really good. We're going to try to find a case that's different than Brandy, give you some variety. That's our options. But the one we're going for is not going to work. So I'm worried that the one in another branch up there that we're watching for the 5th is not going to happen either. Let me double check that. Let me see if I can call. Let's see, that's branch 14. That's like that's a 7-day jury trial. Got bad news out of the case out of Bexar County as well, on the phone with the judge, not the judge, but the clerk. And there's good news and bad news. In Bexar County, one of the amazing, Bexar County, Texas, spelled
Don't miss the forest for the trees.
Bexar. Great little place if you live there, because their courts are wide open. And by wide open, they're like, yeah, bring whatever. You know, bring ice cream and cake and eat it in court. That's fine. We're cool with that. Bring whatever cameras you want. We're cool with that. You know, record whatever you want, broadcast whatever you want. They're wide open. So the only catch is, instead of having a pool feed where I can legally have rights to video access, everybody brings their own camera and they have copyright on everything they use. And so anything that I watch out of there, I would have to be very careful on, extremely careful, and probably only use little bits of it, or else I would get a copyright strike. And I did reach out to KSAT down there, talk to them about licensing some of their footage, and I made the mistake of saying I'd probably only have about 1,000 people watching the trial during the week, during the day, and I guess that's more than they get on their YouTube channel. And that offended them. And they're like, no, we can't do that because that would take away our audience. I'm like, honestly, it wouldn't. None of my people know who you are. Okay, none of my people know who KSAT is. They're not going to find you. But anyway, can you tell us your pickle story? Is it too raw? Well, it's not that bad. It's not that bad. I have spicy maple bourbon pickles right here. Right there, boom. I actually have 2 jars, and this one even has condensation on it because it's cold. It's been sitting in the fridge overnight. I got the last 2 jars off the shelf, and yes, they were on sale, $2.84 a jar, but they were the last 2 there, and everything else around them, the shelves were full. So the word has gotten out about the pickles in my area, and people are buying them up, and so I bought the rest of them. Okay, California is a tough one to get video from. The California trials, they're really tough. Drew Carey, ex-girlfriend. Are you going to be anywhere near the hurricane storm? Yes, I will be in it just later on. Brandy gets it today, or I guess tomorrow, and I'm going to get it the day after. We're actually going to get a 1-2 punch because we have Franklin off the coast of the Carolinas right now, 400 miles off coast with like 120 mile an hour sustained winds, Category 4, maybe it's higher, 150, I forget. Anyway, it's windy out there, and it's stirring up the waves, and they're throwing like 7-8 foot waves where we normally have like 2 or 3 foot waves, and they're gonna high tide will go over the roads and things like that. It's gonna be some damage, but really not very windy here in the Carolinas, but it's gonna cause just mayhem for anyone who's trying to swim unless you're a surfer. So that's going on, and then we get 1 day break, and then another hurricane, Idalia, is going to come across from Florida up over through. It's going to probably get back on the ocean about South Carolina area, and then it may try to like reform and spin back up because it's back over some warmer water, and water is typically where hurricanes strengthen; they weaken over land, and it's just going to go right up the coast. It's going to follow the coastline, and that's going to dump maybe. They say 7-8 inches of water on us, probably in 1 day. So it's going to be a wet day. Free car wash. Anybody who wants to participate, just come park down in my yard. Warning: there may be trees that fall, but that's all. Okay, we keep hearing this court, and it's nothing's happening out of Newman's court, so I'm going to turn that off. Did we ever get Angela's prosecution's case? Oh man. Rudy, it's early in the morning. Give me a little more information so I can jumpstart my memory and figure it out. Silly Claus says, I live in Bexar County. Well, do you have a camera that has an SDI output? I might send you the live view to help out. I would love to live in Bexar County because our court systems are so open. We could stream court every single day from there. Judges just coming in. They're going to start. Please cover this trial. I'd love to watch it with you. I may have to cover this trial because we don't have anything else. I try not to cover the same trial as Brandy, but we might not have any options today. We did talk about it the other day about doing this, but we watch this today. We might have to. I want to find something else. See, it does have some audio issues I might be able to improve. Let's see. I'm way behind. Oh, somebody said stay sage. I like stay sage more than I like stay safe. Sage, I mean, hopefully we stay safe as well, but sage sounds like you're burning incense, and that sounds cool. Don't talk about washing your car like that. I own a detailing business. Okay, so I realized that that unique detail, I'm probably not in your clientele. An undercarriage car wash for me is driving fast through a puddle. That's how I do it. I can count on one finger how many times I've taken my car through a car wash that cost more than a couple quarters. And it was because they were brand new opening. They were doing free car washes. Amazing job. I didn't have the inside details, which I'm sure you guys do as well. But for me, cars are just items of convenience, and they're not. They're not like. They're not items of pride for me. We drive old cars. We drive until they go on the ground. Detailing just removes some of the frame and the rust.
Taking it easy.
Okay. Yes, we can have Judge Newman up for a little bit while we need to look, but we're trying to look for another case. First of all, this is It's another child case. Oh man, it's heartbreaking. This is a child who has special needs, who was not able to get out of the car and.
I'm not a cat.
And dying in a car. First of all, this as a parent in any place that gets hot should be extremely concerned about this. Even if it's a place that doesn't get very hot, just gets warm, because the temperature in a car with the doors closed and the windows up just skyrockets with just a little bit of light. It becomes a sauna so quickly. And having kids who like to play in the car and like to, I'm going to run in the car and grab my blanket, and they'll curl up on the seat, and it can happen so easily. I've never left a kid in the car, but I've had kids that wanted to go play in the car without permission and got in the car. Now I'm petrified of that. We keep our doors locked. I keep the keys away from them. It scares me to death because it's so easy to die in a hot car. You get tired. Okay, you get lethargic. You want to sleep, even though cool air is just outside. Even if you're able to get out, I'm not talking about ones who aren't able. It scares me to death. It's one of those things that, it's like backing over a child. It can happen so quickly, and so dangerous. So it will be quite triggering, I think, for me. But I do want to hear Judge Newman. I'm not sure if we can listen to the whole case. Yeah, I know a lot of you watched more of the parole board yesterday, and it was really good. We might have to do that on a regular basis, going to the Louisiana parole board. That was a lot of fun. I don't know. Did any of them get granted parole? Did anybody, actually win that parole lottery, or did they all lose? Let's see. Weather Watch. Busy day for Weather Watch today, as he's trying to get real work done, but all his computers, for some reason, are showing, spaghetti paths and barometric pressure and projected rainfalls and wind speeds and plane measurement paths and things. Left it there for 5 hours. I heard this. It is just awful. See, I'm watching the plot to kidnap the coroner. Where is that one? Oh, the governor? Is that the one in Texas? Is that Bexar County? What? I thought that was a shooting. It's Judge Newman. Judge Newman's going to be great. He's always great. Let's see. Child was 13 but unable to walk or talk. You've got, I know, I've just a tiny bit about the parents. That they're apparently going to be tried together with a conspiracy charge, which the state will have to prove. If the state does not prove conspiracy, they may walk on this one. The judge has already said, okay, we're going to go ahead with this, but if the state does not prove this conspiracy, you just file your motion at the end of their period of testimony. Can't even think this morning, and we'll throw it out. I'll rule against them. So they've got to prove that conspiracy. Let's see. Brandy is covering this trial as well. We talked about covering this. I think we talked about it before I heard Brandy was covering it. So I don't feel bad about covering it. It's not like I'm jumping on the same trial. The thing is, we have the same audience, and I love what Brandy does. 100%. I love how she does it. I love how smart she is, or the way she talks about things, her sense of humor, her accent, everything about Brandy. If I was not a YouTuber myself, I would be watching Brandy every day. That's where I'm at. And so I don't want to do anything that takes away from what she's doing. And sometimes because we have some of the same audience, that causes that. I like to give people variety instead. Okay. State says the video could take them to closing arguments. Methamphetamine in their systems. Yeah. I would say, Red Pen, I see what you're saying here. I'm like in the same boat. I'm very, very conflicted about this. This applies as much to my mods as it does to every single one of you. If we're ever following a trial that for you does not put you in a good space, that either causes you distress, brings up emotions, feelings, memories that you just don't want to have to deal with, there is zero expectation of you having to sit through that. Okay, I'm not trying to drag you through an experience that would not be good for you. So especially my mods who are here, so so many hours they put in on this. There is no need whatsoever to put your own personal health and well-being, mental health and well-being, second to the channel, ever. And I would never ask you to do that. So please don't even need to apologize. Just say, hey, catch you later on the next one. That's great. That's fine. That's all good. All right. We might have to just do a hurricane watch. Why not cover the trial together? We just cover things differently, Jerry. We've done a little bit. We did one verdict together on the previous trial with Thami. And that was a lot of fun. We'll probably do something like that again, but our styles are different. Our audience is a little different. The shoe doesn't necessarily fit as well. There are some people on her channel like say, look, I need a little more edge than what I get on Recover Addict. That's great. She has, some fun, some humor and stuff that we probably steer away from just a little bit. It's not a huge deviation, but that's there. And some people say, I wish, that he would stop talking so much. I'll go to Brandy instead. And that's great. And vice versa. There's people who say, oh, I like the way RA does this. That's fine. It is hard to combine setups. I run off I think the biggest issue for me is I run off of hardware and she runs off of software. And the software does not work very well with my equipment. We use it for the podcast, but it causes delays, and every single time I've had issues. Okay.
Is that correct?
That's correct. We do have a pretty relaxed style here. Let's see. That being said, I want to be. Let's see. I really want to follow some cases out of Wisconsin. I'm like drawn to that state. I'm not sure why, Ivan. Maybe it's the cheese. I don't know. Maybe it's the ice fishing in the winter. I just think that good things can come out of Wisconsin. Maybe it's because we started up there. But so we're going to watch a little of Newman here this morning as they get going. Probably get through the opening statements. And we'll probably have a good indicator at that point if we want to watch the balance of this. Maybe it's Daryl Brooks you miss. I don't miss Daryl. Judge Doro would be amazing. I went and looked at her docket, Last Poet, and all she does now is family law. It's just divorces. That's all she's got. No criminal, not even any traffic court. No misdemeanors, no felonies. It's just family law. I agree. Every victim needs justice. Sometimes, though, I'm not the best person to provide the venue that will push for that, just because of the content or what we have to sit through. I realize there are people they need justice, they deserve justice, and I'm in favor of that. But sometimes it's just too hard for us to be here and for our audience. Because this is the best state in the union, says Blackbird Speaks. It is in the union. I'm in North Carolina, and it's beautiful. Even the hurricanes want to be here. I'm just saying, this is the spot everything comes to. She retired after Brooks. Can't say I blame her. She's done enough. Rosie, I'm not sure if that's the judge's choice. I know that some of the counties up in Wisconsin have a rotating schedule, and sometimes judges might be on a rotation where they may handle a certain type of cases for a period of time, and that just might be her rotation. And maybe she saw family law come in and she actually hates it, and said, oh, here we go. We got judge coming in. Maybe she said, I want to run for office so I don't have to do family law, but she didn't win in her election, so now she has to do family law.
Morning.
Good morning, Judge.
Yes, sir.
Just a housekeeping matter. We talked about this in the
Audio's going to be a nightmare here.
camera request for a person in our office. I've shown it to all three defense counsel. Nobody has any objection to it. It was just never signed. And before we started,
All right.
I wanted to make sure
Now we say.
that to your Honor's attention.
Okay. It'll be allowed.
Thank you, Your Honor. Good morning, Your Honor.
Good morning.
Now, Kenneth Lewis.
Yes, sir.
Thank you. Your Honor, I sent an email last night.
I received it and read it.
Thank you, Your Honor. Outlining our motion to limit the scope of the prosecution's opening statement, specifically to preclude the following information and argument from being presented during their opening statement. The issues we addressed yesterday, the first one, references to reckless disregard for human life as a misstatement of law. Murder requires an extreme reckless disregard for human life.
So now you're going to read what you emailed me and what you just handed me?
For the record, Your Honor.
Well, the record is your filing. You filed it, so it's in the record. We talked about this yesterday. You filed it, a brief, and now you're reading to me what you filed.
I have not filed a motion on the motion to preclude or limit the scope of the prosecution's testimony.
Well, that's what you emailed it last night. Do you intend to file it?
I have marked it as defense exhibit number 17, and of course, Your Honor, has reviewed everything.
Yes, sir. I'm saying that if you have, when you file, you prepare a motion of whatever sort, you file the motion, and then come and then read to me what you filed. You say, in order to make a record is made when you filed it.
I have to disagree, Your Honor.
Well, you disagree, but I'm the judge, and that's my ruling. I don't need you to read verbatim something that you have filed because it's a part of the record. It's a waste of time. You submitted it. I read it. You filed it.
Respectfully, this hasn't been filed with the clerk's office.
Do you intend to file it?
We can't, yes, Your Honor.
Well, I thought you said it was Exhibit 17 or something.
An exhibit's not, I'm not trying to belabor over the word, but what's marked as an exhibit is not the same as being filed with the clerk's office. We have this very issue in another high-profile case in Columbia about the filing of things and things that is known to a judge. I'm making sure that the appellate record is clear, and I haven't made a motion to limit the scope of the prosecution's opening. Based on Your Honor's position, if I have specific rulings on these matters, then it'll be addressed.
Proceed.
Thank you, Your Honor. Well, since Your Honor is aware and has reviewed the document that was sent, my position is, I understand Your Honor doesn't want me to rehash the arguments. I just need specific rulings on the four matters raised, four issues raised.
All right. What says the state?
You sent us home last night, Your Honor, and you asked the question whether or not there was any evidence that there were any case law talking about drug use at the time of the crime and whether or not that was relevant. I'll hand you three cases, State v. Dickerson, State v. Adams, and State v. Gilchrist, all of which it says yes. And in fact, in all three of these cases, what they talk about is drug use at the time of the crime. And what they all say is that not only is it admissible under 404B, but it's also admissible under res gesta. And all because of the same point that kind of goes through every bit of argument that we've made so far, which is it's all about the state of mind of the defendants in this case.
implied malice, everything from the initial argument by the defense that we had to add some language to clarify things like this. Everything goes back to the state of mind of the defendants. And in each one of these cases, it says drug use at the time of the crime is exactly that. It goes to state of mind. It's not propensity evidence, and it's admissible. They even actually cite one case in there that talks about marijuana use at the time of the crime. Now, this is obviously methamphetamines. It's much more serious drug than marijuana. But even in that case, they talk about the use of the marijuana is relevant. You've got cocaine, you've got crack use in an armed robbery, you've got cocaine use for a murder in which the person bludgeoned the person so much that the cocaine was even used in that. So all of these cases say the same thing, that this is admissible evidence. It's actually not about trying to, as the defense would say, well, you're trying to argue that they did something in the past. They were high the day this happened. And that's particularly relevant when you're talking about why did they do what they did. And the defense is going to argue, unless I'm missing it, that it was an accident. Well, that's exactly what 404B is for, to prove the fact that it's not an accident. And it's a pattern conduct. It's the same with Brittany Honeycutt's testimony. It's the same with Lindsay Lewis's testimony. All they talk about, this is how she acts on a regular basis. All of that is state of mind. All of that goes to why they did what they did. Unless I'm missing it, I assume the defense is going to argue this was just an accident, and we're arguing it's much more than that. As they argued earlier, it's extreme indifference to the safety and lives of others. And that extreme indifference is just in the child abuse case that I handed up to you last night, talks about it's admissible not just under 404B, but under res gesta as well. Those are two of the main issues. I don't really plan on going into a whole lot of other stuff about the legal stuff. I usually leave that to the judge until we get to closing and you talk to us about your charge. So I don't plan on going into that. But as far as those two issues, you asked for specific law on that. I gave that to you. And I would also say this, finally. As far as an opening statement is concerned, we always make opening statements where there's going to be objections down the line. And we still make those opening statements. And I recognize that if I tell the jury something that doesn't come in, then they can make a motion for a mistrial. So I'm not going to be very foolish about that. But I know the stuff that we have. I know it's going to get admitted into evidence. And I ought to be able to do an opening statement that's not handcuffed to what they want to set me to say, which apparently is just to introduce myself and sit down. Thank you.
The judge might be a little loud.
Yes, Your Honor. You didn't address the statement of law. I'd be happy to start there. I can address the one.
Well, I thought he was going to respond to your issues you raised in your.
Well, the first issue was the statement of law.
Sir.
I apologize, Your Honor. Go ahead.
I thought he was going to respond to the issues you raised in your 2:30 a.m. email that you said you were going to file and make a part of the record. That's what we were talking about. The solicitors responded, not specifically to the 5 things that you raised, and I thought he was. But go ahead.
Again, just to outline from before, the first issue is we believe the correct statement of law, based on the case law, is that murder requires an extreme reckless disregard for human life as a possible inference of malice. The second is references of drug use and toxicology. That has not been deemed admissible, as I argued under 404B, when a prior bad act has not resulted in a conviction, then it must be proved by clear and convincing evidence. And then, again, State v. Fletcher sets out the standard for that. And then when we look at kind of the backdrop under State versus Gore with the testimony from Brittany Honeycutt and Ms. Lewis, that when you have testimony that is very similar, it enhances and highlights the prejudice to the defendant. And none of this evidence has been deemed admissible. I've objected to it. And so if Your Honor says it's coming in, then I think they have the ability to argue it. But until that point, I think as far as effective assistance of counsel, I have to know where the boundaries are, or at least try to limit the boundaries for what I believe to be inadmissible evidence. I understand the prosecution's position that I can move for a mistrial later at a later point. However, again, as the appellate court, I know that motions for mistrial are rarely reversed on appeal. It's a manifest necessity standard. Very rare for a case to get overturned on appeal on a mistrial. And so I'm trying to ensure Ms. Panalangan's right to a fair trial. And so that's why I have these motions. The other issue that wasn't addressed was the deferred ruling that Your Honor had on our motion to suppress the untimely and prejudicial disclosure of evidence. And that will be any references to the workings of the key fob or how the car operated, whether the keys were locked in the car. And so that ruling was deferred as well. So we have those 4 issues that, again, in my position, to ensure her right to a fair trial, I just need to know the boundaries for where the prosecutor, because if I don't know, then I have to object. I'd rather not object during the opening, and then that turns into the situation we're in.
Yeah. Well, I'll say as to each party, I don't know how you would expect to convince the jury if you have no respect for the juror's time. Before we left yesterday, I inquired as to whether there's anything else that needs to be addressed before opening statements in order to determine the most opportune time to have the jury come in. And each side says, no, there's nothing. We're ready for the jury and opening statements at 9:30. That's my primary discuss at the moment. And I hope that pattern doesn't continue throughout the trial. Certainly you have an opportunity to argue and put on the record whatever it is you have, but when you represent to the court that you have nothing, and then at 2:30 a.m. You submit a barrage of things that delays the opening, it's unfair to the jury and shows a lack of respect for the court and the jury, in my view.
And respectfully, Your Honor.
You disagree?
No, my point is I wouldn't raise it if at the moment I had thought about it, I would. As the drive home, I started to think about what I needed to do as far as the opening. And then, and obviously we could have argued it yesterday. But again, respectfully, for the jury's time, Ms. Panalangan's facing life in prison.
I understand the penalty, and you don't need to repeat your again. Response by first, Mr. Lloyd.
Your Honor, only with the exception of the lie/propensity/race gesti motions, I don't think we have an answer that applies to us. I would join in counsel's motions to stress on the same basis.
Yes, sir.
To be specific about his motion that he filed, and before I don't plan on going into the key fob things, I recognize that you held that under advisement.
And I grant that motion of the defense.
Thank you, sir. Number two, for the 3 cases I handed you, I heard yesterday, which my understanding was when we left yesterday, your instruction for us to go do that research. So that's what I did. And interestingly, that applies to not only 2, but also to 3. And I do plan on going into the nephews, the other stuff as far as the extreme recklessness. I do not plan on going into a great deal about the law in this case, as I said earlier. So I apologize. I thought I could address those. But again, it's an opening statement. I think we need to get to the opening statement and do them. And it's not unusual at all that you do opening statements with evidentiary and with the skill opinion.
Judge Newman is
with regard to the
jury
motion to preclude the solicitor from misstating the law regarding the question of whether extreme recklessness is required for malice, based on the case that worked to conclude that reckless homicide is not a lesser included offense of murder. I deny the motion to limit the opening statements. And quite frankly, whether the word reckless is used or extreme reckless is used, it's not an instruction of law to the jury, and I would expect that the solicitor would not misstate the law. If there is an attempt to misstate the law, then an objection should be made. I'm not into dictating words the state or the defense should use. Regarding the drug use and toxicology, I find that is admissible testimony based on it occurring during the race gestae. It's admissible to give the jury a complete picture of things that were going on according to the state's theory. Part of the race gestae also shows could show the state of mind of the defendants. To the extent that, well, first it's relevant, and to the extent that it may be prejudicial, I find that the probative value outweighs any danger of unfair prejudice due to the state's burden of proof, and weighing both things is admissible, whether or not the state can establish that by clear and convincing evidence under Rule 403, 404. I can only judge things based on the statements that were received and submitted by the solicitor yesterday of Ms. Honeycutt and the other young lady, and I find that that prior conduct is likewise admissible as part of the race gestae. As it relates to matters that occurred the week before the death of the child. There are obviously some contents of the statement that speak of incidences occurring at a more remote period of time, and we'll address those issues during the course of the testimony. The parties are welcome to proffer testimony if you want to give the court more to go on, but as far as what I've had, reviewed, and received at this time, I find that the motion for number one regarding the solicitor's opening, the motion is denied. Regarding references to drug use and toxicology results, the motion is denied. With regard to the babysitter and Lindsay Lewis, I assume she's the one who, let's see. Statement of Lindsay Lewis is admissible, all as part of the race gestae, and to show any lack of accident or state of mind of the accused. I grant the motion to exclude expert testimony regarding the key fob.
Thank you, Your Honor. And so I won't have to object during opening. Can I get confirmation that the issue is reserved? I'd rather not do that. Out of fairness to the prosecutor.
Can you get what? Confirmation of what?
That the ruling is final, so I don't have to object during this opening statement. Out of respect.
Preliminary rulings are preliminary rulings. You object when you say, I am not precluding anyone from objecting as you might see fit to object.
Yes, Your Honor.
That's throughout the trial. Anything further before the jury comes in?
Not from the state. No, Your Honor. Thank you. No, Your Honor.
All right, you'll bring the jury.
All right, so this is the beginning. I'm trying to do what I can for the audio. The way the microphones are located needs a lot of help. Judge Newman already is not a happy camper with the defense specifically. Now, I don't know if defense has different lawyers for each defendant as they're being tried together, the two of them together. Do you want an objection counter? Let's not count all the objections in the beginning, right? He'll start it from now forward. We'll do an objection counter. Let's see. Give me a minute to get this set up. Oh, wow. Let's see. Yako, yee-hee. Oh, sorry. Yaku. Yee-hee. 4 months in family feels like a year. Thank you so much. Katrina, member for 8 months. 8 months. Holy cow. One of our first, if not the very first, subscribers. Thank you very much, Katrina. Corn Dog gifted a membership as well. A couple gifted memberships previously, in addition to Selena Kays. I'm sorry if I wasn't able to call you out during the judge speaking, but nobody interrupts Judge Newman. Holy cow! Adjust your white balance, cameraman. This is crazy. Are we just cycling through the color? We're like yellow, and then we're blue.
Good morning. All right, welcome back. Ladies and gentlemen, if you all will stand to be sworn.
Selena gifted another 5.
Raise your right hand.
Thank you very much.
Do you solemnly swear or affirm that you shall well and truly triumph and true deliverance make between the state of South Carolina and the accused at the bar, and the true verdict give according to the evidence and the law, so help you God?
Well, ladies and gentlemen, you received a summons, I imagine, 2-3 weeks, a month or so ago, informing you that you had to report for jury duty here on yesterday. And you all responded to that summons by showing up yesterday. Then we went through a process called jury qualifications process, and each of you were qualified or are qualified to serve on jury duty. Then we went through a voir dire process where we ask each of you whether or not there is any reason why you cannot serve on the jury and give each side a fair and impartial trial, and all of you indicated that you could be fair and impartial. You were then selected by the state and the defense to be the jury in this case. Now you've just taken an oath, and the oath is to well and duly try this case and to render a true verdict according to the law and according to the evidence, so help you God. Now that's the oath you just took. And if you hold firm to that oath, then at the end of the process you will have fulfilled your duty on the jury, and no one will have any right to complain of a verdict that you render. And so we look forward to working with you in this case, and to having you fulfill your responsibility as jurors. Now, the defendants in this case have been charged with murder, causing great bodily injury on a child, and criminal conspiracy. As to each of those charges, each defendant has pled not guilty, and they are presumed to be not guilty, and they cannot be found guilty unless the state presents evidence that convinces each of you of their guilt beyond a reasonable doubt. And that is the purpose of the trial. Now, you will, at the end of the process, be asked to go back and to deliberate and to reach a verdict of guilty or not guilty on each charge in each indictment as to each defendant. And in order to be in a position to go back and to deliberate, you must receive the evidence, you must listen to the evidence, you must pay attention to the evidence, and the evidence generally comes from testimony that will take place with this witness stand together with any exhibits which has been made a part of the record. Exhibits might include photographs or various drawings or something other than testimony. So you will listen to the testimony and you receive any other evidence, and you will evaluate that evidence, and out of all the folks who were summoned to come here for jury duty, and you know it's a lot of people, out of all the people who were summoned to appear for jury duty, out of all the people who live here in Colleton County, out of all the people who live in the state of South Carolina, in fact, out of all the people who live in the United States, even the world, only the 12 of you who deliberate can decide whether the defendant or defendants are guilty or not guilty. So you play a very critical and important role in the court process. We'll make sure that you remain as fresh and focused as possible by taking breaks as is necessary. If at any time you need a break for some special reason, get my attention and you have a break. As I said to you earlier or yesterday, that once you're selected on the jury, you cannot discuss the case with anyone. You can't talk with your fellow jurors about it. You can't talk with any family members about it. You can't talk with anyone who works here in the courthouse about it. You can't talk with anybody about the facts of this case until you have received all of the evidence. And as I said, out of all the people who've been summoned, only you can decide the facts of this case. Now, just as only you can decide the facts of the case as the presiding judge, I am the sole judge of the law, and you must accept as correct the law as I stated to you at this time, during the trial, and in greater detail at the end of the trial. Each party is represented by counsel, and certainly the lawyers play a very important and critical role in the process. But remember, what a lawyer says is not evidence. The evidence is the testimony and exhibits, and they certainly will argue their positions to you and play their critical role in dealing with witnesses who testify. Later in the process, I will appoint one of you to serve as the foreperson of the jury, and the foreperson will then act as the spokesperson for the jury, and the fourth person will have the responsibility, in addition to serving as a spokesperson for the jury and communicating with me as is necessary. The fourth person will preside over the jury deliberations and complete the verdict form at the end of the process, and that verdict must be unanimous. Look forward to working with you on this case, and we will proceed now with opening statements, first by the state. Yes, sir.
Okay, I just want to...
Very hot.
do you guys want to stick on this trial? Or I did not want to cover this one because of the content.
These two people over here, Larry King and Rita Pangalangan, put a child in the back of a car and left it there for 5 hours and 41 minutes. So it was a hot day. At 11:15, when this all started, the heat index was already 89 degrees. It would get close to 100 by the time they ever got that child out of the car. And that was outside the car. That was out air temperature outside. Inside the cabin of the car, we reach a minimum of 118 degrees with a heat index of 135.
That's hot.
So what happens when you put a child in the back seat of the car and leave them there for 5 hours and 41 minutes? They cook to death. They are tortured and they are cooked to death. The child's internal temperature, when checked by the coroner, is 109.9 degrees. And that's what we know. Because the thermometer doesn't go any higher than that. The child's brain gave up. The organs shut down. She had blisters all over her body. And she died in the back seat of that car. She died, the technical way, the scientific answer to that was hypothermia. You'll hear expert testimony telling you that the child died of hypothermia.
Hyperthermia.
But that's not why you're here. Because she didn't actually die of hypothermia. She died because those two people there treated that little girl like baggage. They didn't forget her. They didn't put her in the car and forget her. They put her in the car because to them, she was baggage. You see, the little girl wasn't like every other 13-year-old girl. She suffered from cerebral palsy. She couldn't walk. She couldn't talk. Her hands barely worked. She could not reach the car door to open it to free herself. She couldn't even scream for help. Not that they would have cared. She was totally dependent on other people for her safety. The other thing about her, again, not like a normal 13-year-old teenager, she couldn't be shipped off to go with her friends to the mall or something when Rita and Larry wanted to be alone, or they wanted to do the things they were interested in. She had to be taken care of. She had to be watched and cared for. Or she had to be put somewhere out of the way. And on August the 5th, 2019, that place was the backseat of the car in direct sunlight. And what were they doing? They were high on meth. Objection, Your Honor. Prior motion.
Objection's overruled.
Not only were they high on meth, they were standing right in the car. They were swinging on the swing. They were hugging. They were kissing, all of which you'll see. And they would go inside the house and stay there for hours. They would come out. Rita would smoke cigarettes. They would hug and they would kiss. They'd go back in the house. All the time, the child was literally cooking to death in the car. She was to them baggage. And they need to get her out of the way so they can do what they need to do. The decisions we all make every day, most of us have choices.
Most of us have the ability to make decisions, how we act, what we do. And those choices have consequences. Rita Pangling chose to put that child in that car. She chose to focus her attention on Larry, to talk to him, to kiss him, to hug him, to go inside with him. She chose to do meth. Larry, same thing. He chose to put the child in the car. And I say put, that's gracious. You'll watch it on the video and see how he puts that child in the car. Just like he would a suitcase. And he chose to spend his time outside the car and inside the house with Rita and hugging and kissing. And on meth. Those are choices that they made. And those choices have consequences. The only person in this case that didn't have a choice was Christina. She had no choice. She was totally dependent on somebody else for her safety. And they didn't care. And that's what this case is about. Now my job is to prove to you this case beyond a reasonable doubt. What I've told you. If I don't do that, your job is to come back here and find me not guilty. Ladies and gentlemen, I'm going to ask you after you hear the testimony, after you see the video of the case, after you see what happens with this child, to come back here and give us a verdict that speaks the truth. This child died not because of any other reason. So you have a matter of law at the appropriate time for that.
The objection is sustained as to the solicitor's reference to speak the truth, and you're to disregard that reference.
When this is over, I'm going to ask you to come back and give us a verdict that says this child died. This should have died. Because they didn't care.
Mr. Loy?
Thank you, Your Honor.
Yes, sir.
Morning. Y'all, 14 votes have been selected in this case. Back in your laws. In the case which I'll tell you now is both one of the easiest cases you could have been making, and in the second breath, one of the hardest. It's one of the easiest cases because, as you'll hear, probably several cases throughout the course of this trial, you as jurors are what we call the finders of the facts, or the judges of the facts. And during the course of the trial, it's your job, it's your primary duty during the course of the trial to determine what the facts are. His Honor is referred to as the judge of the law. At the appropriate time, he will tell you what the law is, and he will apply it to the facts that you figure out. That part's not going to be hard. Okay? Y'all will come to an agreement as far as factually the sequence of actions that took place. That part may be hard. It'll be easy. On the other hand, y'all got to pick for a really hard case. Because this child did expire. She died roughly by the manner of death that the solicitor described. And it's hard to listen to. It's hard to know. You've probably seen a newspaper article or a news story sometime about this happening in the past, if it has happened in the past. And it's a lot easier if you can turn the page and change the channel. Because it's real bad. And there's no way to sugarcoat how to do it. Just listening to it is going to be hard. Secondly, the other part of your duty that's going to be hard is you are required to keep an open mind throughout this entire proceeding. That is, you don't keep a score. Here's a point, there's a point, there's a point, here's a point. You listen to the testimony as it comes in. You look at any exhibits or evidence that is introduced, and you file away and you get the complete picture. And at the end of the case, when the judge was giving you the law and told you to take it back, and he's giving you the indictment, and put the case in your lap, and he says, go on back to the jury room and deliberate. That's when you begin to decide what's appropriate. Until then, you just don't have the rules to do it. The rules by out and the rules
claw on the game. So you're required to keep an open mind. And I can see sometimes that's hard because it may have been hard to keep an open mind just having heard that dramatic statement. And that was dramatic. But you got to put that aside, watch it all, and once the judge gives the case to you, you apply the law, and you decide your verdict. Now, in this case, the facts are going to substantially not be in dispute, I don't believe. In fact, the evidence in this case will show you that Mr. King and Ms. Pangline had in the past, several years ago, been involved in a relationship, a romantic relationship. It didn't work out, and they split up. And maybe a month, 5 weeks, a month, before this tragedy occurred, they had gotten back together. They had reunited. And that, ladies and gentlemen, is one of the worst decisions that Mr. King ever made at this land. They got back together. They didn't live together. It wasn't like that. She had a house on the other side of town. He had his place, but they were dating, and they continued to relationship. And on this particular evening, the night before this child died, Miss Pangline and her child had spent the night at this kid's house. And in the morning, Mr. King, he had reason to believe that Miss Pangline had been unfaithful or messed around with another guy or something like that during the time that they got back together. And he confronted her on that, and they went back and forth a little bit. She said, yes, this happened. And at that point, he told her, now, he's not raping any of that stuff, but he said, yes, it had happened. He said, y'all got to go. I can't deal with this right now. I'll talk to you later. But y'all have to go. And they went back and forth a little bit. This time line. He said, okay. But I can't carry Christina, as you've heard, but you know, that I can't carry her. My back is hurt. I've got a kidney issue. And Larry said, I'll carry her. And I didn't, well, you will have a chance to view this video. And what the videotape will show you is that Mr. King came out of the door, cradling this child in his arms, completely appropriately, completely properly. Nothing abusive or disrespectful about it, nothing rude or wrong. He carried this child. He's not fighting with this Pangline. There's nothing that makes him look angry, mean, malicious, or hateful toward this child. He carries the child to the car, appropriately, and you will see that. The back door's open. If he is there, he has to turn the child. So she goes in feet first and not head first. And he does that. He turns her in his arms. And he places her in the car. He backs up, and this mom go over and do what she needs to do to prepare the child to travel. Put the seatbelt on, do what she does. And you can see mom in the back. That's with the child. Mom steps away and closes the door. At this point, Mr. King's out of the picture. The child was out of his house, he's in mom's car, the door's closed, he's asking to leave, y'all are on your own. She's not his child. She's not his adopted child. He doesn't pay for her, he doesn't bathe her, wash her, he doesn't feed her, he's not financially responsible for it. Mom's child was put her in the car and said, y'all need to go. Miss Pangline turns around. The video, solicitor records, doesn't have audio, but it's pretty easy to follow the conversation that ensues. And y'all will see that Miss Pangline is pleading the case. I'm sorry, can we get past this? And Larry is telling her, you get to go. And they go back and forth for a while. Now, the car's running. Larry has every reason to leave the air conditioners on. The child is in the custody of her mother, who is raised her at this point. And Mom's got this child. He turns and he walks into his house, and Mom walks behind. Sometime later, Mom comes out, goes to the car. Looks like she opens the back door, perhaps checks on the child, everything okay. Gets in the front seat, momentarily, gets back out. Comes out another time, it's 2 times, checks on the child. Goes back in the house. And after approximately 2 hours after the child is left at home, the 2 of them come out, and the tape is obvious. They can't get in the car. The car's locked, it's running, it's locked. Now whether the key fob is in the car, or lost under the bed in the house, or dog ran off with it, it really doesn't make any difference. It's obvious they're trying to get into the car. Now, Mr. King at this point, he's volunteered. He's trying to help. I mean, there's a legal obligation here for that. But he says he goes to the shed and he gets a wedge and he tries to go to the window and get the car door open. He can't get it open. He did. He can't get it open. He almost. Can I break a window? Just bust out a window and that'll do it. It doesn't seem like an emergency at this point. This AC's doing in the car. Can I just bust out the window? Mom says no, it'd be cheaper for us to just run to my house and I'll pick up the other two files and we'll come out. It's okay. And again, sure he doesn't. He got his feelings hurt earlier, but he's trying to help. And they get in the car and drive Mom over to her house. She gets the key fob and they come back. And you watch the video again, and there's a little bit of issue. They had trouble getting in the car. They do get the car door open, and Mom opens the door, and they find that the child is deceased.
It's an objection counter
That the state has to do every time they call an indictment a trial or a if they do those two things, they win every time. If they fail on either one of those two things, they lose every time. First, they have to prove that the crime alleged in the indictment, the charging date, that you'll have in the security, the crime alleged in the indictment happened. They always have to prove the crime. I can't prove the crime happened. You sure can't prove anyone else. It's a robbery case. You have to prove somebody got robbed. If it's stealing a car, you have to prove a car got stolen. You have to prove that the crime occurred. And secondly, they have to prove that the defendant, the person charged, is the one who committed the crime. In this case, Mr. King, I'm only concerned with Mr. King. Ms. Lang has her own attorney, her own defenses. She's not on my plate. I'm not here to shoot at her or to defend her. I'm here on Mr. King's behalf. And he has 3 indictments. He has an indictment for murder. Murder is a very specific crime. It's a very specific term of art. And the judge will instruct you on what it means at the close of this case. But when you apply the laws, the judge instructs it to you to the facts as you have found them, substantially as I have described. You will find that at least as relates to Mr. King, there is no grounds, there is no basis, there is no way that he is guilty of murder. It's just not there. It can prove the crime of murder. It's whatever happened there as relates to Mr. King is not murder. It's a tragedy. It's a heartbreaker. It doesn't make it murder. Secondly, he has a crime of causing great bodily injury to a child. And as you watch this video, you'll see that what he does is bring this child out of the house, place the child in the back seat of the car, relinquish any control, custody, claim, obligation, or right to this child to her mother, and step away and say, don't do it. And there's nothing about his involvement when he carries this child, handles this child, puts this child in the car, as any way going to injure her. Further, you'll hear under the law, the statute doesn't even really apply to anything. They're not the ones that they do. Last, there's an indictment for conspiracy. And you'll have that indictment with you in your room also. And I will tell you now, I will tell you unapologetically, that indictment is a garbage indictment. It's the last straw. It's to throw it in there and see what happens. There's nothing to this. Read this indictment. It says the 2 of them conspired to do something. It doesn't say what. I don't believe for a minute the solicitors can have the audacity at the close of this case to get up and tell you that Mr. King conspired with someone to murder this child. Conspiracy means 2 people come together with a plan to commit a criminal act or accomplish some criminal intent, that they got together and said, how will we kill this child?
Objection. Not all conspiracy.
The judge will instruct you. Proceed.
Yeah, the judge, I will instruct you as to the law. You may proceed.
The judge will instruct you as to the law. So, they may have conspired to murder this child, They may have gotten together some wicked plan. How can we hurt this child? Or conceivably, it could be a conspiracy to cover up what happened after they discovered that the child was deceased. They might be in trouble. And in support of that, the state's probably going to show you that when the law enforcement was called, when they responded, Mr. King was as honest, as helpful, as straightforward as he could be. He told them what happened. He said, we were in the yard, I put her in the car, I thought the air conditioning was running, everything seemed okay, Mom went back outside. 2 hours went by, oh my God, I can't believe this. Miss Pangoline's story did not align with that. Her presentation was something different. And if you hear those, it's obvious they're not together on this. They are miles apart. Most of what you need to know about Mr. King's evil heart and desire to hurt someone and put their life would be revealed to you when you listen to a 911 call that day. Because he's heartbroken with any allegation he's been different, mean, malicious, falls in the face of that recording itself. If I've talked too long, I'm sorry. It's a pretty important day. And if nothing else, please try to honor the oath and keep an open mind until the end of this case and you decide when the judge is. Okay? If you do that, even though I know it's hard and I know that people have a tendency to prejudge, if you don't do that, then this goes to what a lot of us would call a sacred proceeding. That is, that you are called to judge your fellow man into something more of a farce. And don't let that happen. Thank you.
Mr. Phillips.
Yes, we have two defense lawyers who are going to go because they're two separate defendants. So we have each have their turn. This guy is not impressing the judge at all.
As a father of 2 girls and a baby boy, I know a parent's worst nightmare is the loss of their child. That death is unimaginable. This case, what happened that day, is an absolute tragedy. Let me say that again. What happened that day was an absolute tragedy. We know and accept mistakes were made. That things should have been done differently. There's a lot that happened in this case. There are a lot of things that you're going to see and hear that invoke raw emotion. Raw emotion. And you swore before God to ensure that you hold the government to that burden. To prove that this case was murder. This case is about a lot of things, but it's not murder. All the evidence from which you make a decision has to come directly from that witness stand. When you took that sworn oath, if after you heard the government's opening, you felt like you kind of it made your mind up, you violated that oath. And I'm not saying that to attack you. I'm saying that because we haven't heard any evidence yet. And you have the chance to take a step back and do this the right way, the way you swore an oath to do. To listen to what actually occurred. We wouldn't be here if the government wasn't seeking to convict Rita of murder. She's not guilty of murder. We accept responsibility. Mistakes were made. She should have done things differently. In having that ability, it is her living nightmare. Wake up in the morning and go to bed, and that's all she thinks about. Is what she could have done differently. If anybody's made a mistake,
and they've had that opportunity where they think 1,000 times in their head, I should have done this, I should have done that, I should have broke the window, I should have been more urgent, I shouldn't have left her in the car. She owns this. It's on her soul. This is not a murder case. This is not a murder case. It's a lot of things. One that she'll have to pay for. She'll have to pay a price. There's right. There are consequences for your action, but it's not murder. I don't want to minimize that. We're not going to make any excuses in this trial for what happened. Like I said, it's going to invoke raw emotion. It invokes raw emotion from me. Nobody's going to downplay that. Now, again, the government has to try to show that she's guilty of murder beyond a reasonable doubt. Now, how? Well, you can ask yourself, why do we believe she's not guilty of murder? Well, I contend, and certainly you can ask yourself this, if the government believes she was guilty of murder, why 3 years later do they charge her with great bodily injury or infliction of great bodily injury to a child? If they believe she was truly guilty of murder, why hedge the bet? Why charge her with something else? If they were solely based on that. And I contend there is zero evidence of a conspiracy. Zero. Absolutely none. This case is on video. It's a surveillance cam from Mr. King's residence. There's no smoke and mirrors here. It's all there for you to see. All there for you to evaluate. We're not running from it. And the only reason you're here is because they want a conviction of murder, and that's not what happened. Period. And in this case, again, you will have to deal with very difficult things. You'll have to make difficult decisions. But you have sworn to set aside that emotion. I know it won't be easy. But again, you've got to make your decision based on the actual evidence presented and not on the grave emotion of what pulls up in you when you watch the video, because it does hurt. Nobody's going to deny that. The person who knows it hurts the most is Rita. Rita has 2 adult daughters. Rita served this community as a teacher for 25 years. She was Teacher of the Year twice. She has a master's degree. She's highly educated. You're going to hear them say that she should have known better. She should have. We own it. 100%. But it's not murder. Again, this is an absolute tragedy. No denying it. But don't compound that tragedy by giving in to what the government wants. Solicitor's office, again, in these high-profile cases, you have the cameras, the lights, when they're seeking conviction for murder. This case is not murder. When you hear all the evidence, we are going to be confident when we come in closing to come before you and say, find Rita Panlanigan not guilty of murder. Because that is justice in this case. Justice will come for Rita. It's not murder. Thank you.
State House Helen Godley, stand.
See if we can get some
Stand
closed caption on this.
just a moment. Make sure you all.
It's yoga time with Judge Newman.
Everybody, let's stand for a moment.
Okay. Let's see about here. Just 1 second. Okay, there we go. So you guys have asked to stay on this case. We talked about covering this case before, and then thought about trying something else. The other cases all fell through, so we're back on this case. The audio is awful.
State your name again for the record. Spell your last name.
My name is Hallie Godley. My last name is spelled Godley.
Agent Godley, if you could tell the jury your name, please, and what you did.
My name is Special Agent Hallie Godley, and I work for SLED Narcotics currently.
How long have you been with SLED?
Going on 5.5 years.
I don't know we call it SLED, but what's the full title of the State Law Enforcement Division?
Correct.
Okay. So you've been with them for how long?
About 5.5 years.
Okay.
This guy doesn't listen to the witness.
With SLED, what do you do?
I investigate narcotic cases.
Prior to this, back in 2019, what did you do?
I was with SLED at the time.
And what specifically was your job duties there?
A narcotics investigator.
How did you get involved in this case as a narcotics investigator?
I was returning from a training class in Jasper County that day, so I was traveling back northbound on 95, and when this call came out over the Colleton County Dispatch radio channel, I was at exit 42 on 95, and this incident location was right down the road from where I was at. And when the call came out as a 12-year-old locked in a car, unresponsive, my first thought was, at the time, my daughter was 6, and she knew how to get out of a locked car. So
Objection's overruled.
So it immediately sounded suspicious to me.
Let me stop you there just briefly. As you were mentioning 95, I want to give the jury some idea about where we're talking about. This is State's Exhibit 7. If we've already shown this to the defense.
Any objections to it being admitted? It's admitted.
Your Honor, I'll prove this off, and if this gets anybody's way, I'll...
Courtroom's already a mess.
All right, let me show you. This is State's Exhibit number 7. Can you identify that for us?
Yes, sir. That's an aerial map of, it looks like Colleton County,
Okay.
with...
I'm sorry, go ahead.
With 2 addresses identified.
All right. Now, on this map, if you could just give us, can you still see it?
Yes, sir.
Okay. Give us some idea about the proximity of this. This is first of all, is all of this in Colleton County?
Yes, sir.
All right. And so you are traveling, I believe, on Interstate 95 at the time?
Correct.
Right. Give me, if you could, the addresses on that, and tell me about this area, please.
Stand.
Yes.
As long as you keep your voice up.
Okay.
We are in South Carolina
The top right address is 1867 Academy Road, in Walterboro, South Carolina. I'm familiar with this address being the home address of Rita Pengaling.
Okay. And the lower address?
The lower address is 11685 Low Country Highway in Ruffin, South Carolina, and that is the incident location for this investigation.
All right, so that is where you responded to?
Correct.
Okay. When you arrived on the scene at, make sure I get this exactly right, the 11685 Low Country Highway, could you describe what you find once you get there?
Initially, as I was responding, initially I passed the residence, and as I passed it, I saw 2 legs sticking up out of the tall grass in the yard. And in my mind, it reminded me immediately of at the time, my daughter had the life size on an Elsa dolls.
Just tell me what you saw. Just speak up.
So as I returned back to the yard and got out of my vehicle, I saw Christina on the ground, face down in the tall grass, and Larry walking around the front yard.
All right, and you say Larry, who are you talking about?
The individual in the button-up shirt, light blue or white, dark brown beard, with glasses and bald head.
And you know his full name?
Larry King.
And Your Honor, the record, she identified the defendant, Larry King.
It does.
And Larry King, what is he doing when you get there?
He's walking around, and I believe he was still on the phone with 911.
Did you see Rita Pengaling?
Not initially.
So tell me, when you walk up on the scene, exactly what do you see?
I see Christina laying in the tall grass, face down, Larry walking around in the front yard, and the front door of the residence was open.
Let me show you what's been marked as State's Exhibit 5. Ask if you could identify this, please.
Yes, sir. This is a accurate depiction of the scene when I arrived with the Volkswagen parked in the front yard and myself and...
That's fair and accurate depiction of how the scene looked when you arrived?
Yes, sir.
Your Honor, this time we move State's Exhibit number 5 into evidence.
Okay.
Your Honor, we're going to publish this. This is here, the hard copy. We'll publish it on the...
It is, puts the court at a great disadvantage to rule on the admissibility of evidence not seen by the court. Do you have copies of these exhibits?
Yes, sir.
Including, you showed her something and had it admitted, and I can't see it. Do you all have copies of the exhibits? I can get copies later, but I would like to have copies of exhibits.
Copies of the first two, State's Exhibit 7 and State's Exhibit 5.
And number 5 is admitted, as well as number 7 has already been admitted.
Tell me what this is depicting. This is State's Exhibit 5 up on the monitor.
This is right when I got on scene that day.
So is this you in the blue shirt?
Yes, sir.
Is that a blue shirt, by the way?
It is.
Okay. And who is that standing beside you?
Larry King.
Okay. And where is Christina the child?
She would have been off the rear driver's side bumper of the car.
All right, so you can't see her. She's on the other side?
Correct.
And again, where is Rita Pangling at this point?
Inside the residence.
Your Honor, we need a matter of law. Also for Mr. King, Your Honor.
Ladies and gentlemen, we'll have you go to the jury room for a break. Please do not discuss the case.
Judge Newman is not in a good mood right now. For background story, those of you who are saying, where have I seen this judge before? We saw Judge Newman during the Murdaugh trial. He was the judge for Alex Murdaugh. Shortly before Alex Murdaugh's trial, which was also involving the death of a child and also a wife, the murder of a child and a wife in that case, I can say that now, Judge Newman lost his own son. His own son passed away. And now he's presiding over another trial where the parents, or the mom and a boyfriend, I believe, are charged with murdering a disabled child.
For that remark, since we know that it's not a final ruling, I think the state seeks to admit all 4 photographs into evidence at this time, and so renewing our prior pretrial objection to those photographs with those arguments under Rule 403, going through the case laws. We cited even the new case that recently came out from our Supreme Court on August 9th, Nelson. Specifically, Your Honor, again, I'm not going to rehash. I know we went through that thoroughly in the argument pre-trial, but we renewed that objection and need to hash that out.
Mr. Lord.
Likewise, Your Honor, I believe under Nelson what they have described in that case, as well as a trend of the law to suppress the pictures which don't make any issue. Contention more or less like this, just not probative. We have conceded what the solicitor said. This child was in the car, it got so hot, she basically baked to death. She was pulled out. The pictures don't demonstrate that any more than the words themselves do. Plus, these pictures have other prejudicial effect. And that this is a disabled child, and that's not the fault of either one of the defendants, but they are even more pathetic or emotional, and that the child looks emaciated. The child is wearing a diaper. And those have nothing to do with this, and they don't make it any more or less likely that there was malice involved. The actions are pretty much what we have to see if they were. The state said this happened. We said this happened. What do these prove? And what do they go to show that is being contested? And I believe the answer is nothing.
I don't believe that was the answer. Let me hand you, Your Honor, first of all, the 4 photographs. Those are, and obviously I will still need to authenticate those from the witness. Nelson was an autopsy case, Your Honor. These are not autopsy pictures. These are crime scene pictures, which is why I handed you Upstate versus Kelsey yesterday. But even under the analysis of autopsy pictures,
these will be admitted.
Specifically, the Supreme Court has routinely said that if photographs are probative, if they tend to shed light on any issue, if they corroborate testimony, if they are enable the jury to better understand testimony, including showing the condition of the victim's bodies, the probable type or location of the injuries, the position in which the bodies were discovered. Again, these are discovered as Agent Godley testified. This is right after this event has taken place. In fact, Larry King is still on the phone with 911 when it happens. This is also, you will see, for the 5 hours and 41 minutes that the child was in the car, both Larry King and Rita Panglangan approached that car at various times and actually look in the window. So at some point they're seeing exactly what this is and these blisters and the things that you're seeing. What's also, I think, important, and she just testified to this, at least part of it, is that when she gets there, the child is laying by herself in the grass. Rita Panglangan, the mother, is nowhere near. And that's exactly how they found the child, and that was the condition that child was in throughout the entire event.
All right. Exhibits number 2 and 4 are admitted over objection as they depict the scene at the time the officer arrived and is being used to further describe her testimony, and that the pictures are not of such a nature that their prejudice exceeds the probative value. With regard to number 1 and number 3, what do these pictures purport to show? That is of significance.
This is how on State's Exhibit 3. These are it's actually the same photograph. This is the bottom half, and this is the full body shot. Again, not only is it how the child was found, you can see the blisters that were on the child's body.
You can see it on both photographs, or can you?
Yes, you can.
So they show the same injuries.
They do. The only difference is you can see the child's face, which I believe that both King and Panglangan would have been able to see if they looked in the car. And there's no way for me to tell you, other than to tell you on the video, they are looking in the car at various times, sometimes to look at, supposedly looking to see how they get the car unlocked. But there are various times in the video in which they're looking in. This is what they would see with that child. And Your Honor,
and I'll get back to you. I'm talking to the solicitor.
Yes, sir.
And the tag on the feet of the child.
That is they had to put I think the coroner put the tag on that.
Was this at the scene or at a different location?
No, it's at the scene. It's right there, yes, sir. And I think you can see the grass around it, although they had to, they got a sheet to try to cover the body.
All right, Ms. Phillips.
Thank you, Your Honor. Based on Your Honor's ruling to admit the 2 photographs as...
I haven't excluded the other 2.
That's right. That's where I'm going.
Right.
Based on Your Honor's decision to admit those 2, our argument would be, again, that there's nothing that testimony can't provide that's not already contained within those 2 photographs that would be highlighted by those. That is not how she was found in the scene. Has the coroner's tag, has the sheet behind her. One's obviously an enhanced photograph with the injuries. These photos are nothing more to inflame the passions and prejudice of the jury, to have them make a decision based on an improper basis, not the evidence themselves. And Your Honor, has decided to admit those two photographs. With that, to me, those additional two photographs, the probative value would be substantially outweighed by its prejudicial effect.
Mr. Loy.
You know, I would join. I don't believe that those photographs show anything that's not can't be described by a witness on the stand adequately, and it's not adequately shown in the pictures that are there. I would note that on in Nelson on page 3, the part that's in the dentist, they do what we do, and the Supreme Court seems to think it's important. Where in the opening statement, counsel said, "We agree the victim was brutally murdered. We agree she had at least 90 wounds to her body. We agree with the prosecutor about the cause of her death. We agree about where she was killed. We agree in general what the murder weapon was. And we agree that these people were there." We're in the same, and the Supreme Court seems to think that's an important point, because they quote it, they admit it, and then they go further and say, we agree with that, and we think that negates a lot of the necessity to bring this in, and it just makes it inflammatory. At this point, I think it's also cumulative, inflammatory as well as cumulative. If the state want around, I don't think they need this one too.
Last word, Mr. Solicitor.
Testimony. Again, everything in here goes to the state of mind of these two people. These two people were able to see that child in the car when they looked in the car, and that's what they saw. And that's one area that makes it particularly, I think, important.
There's no foundation.
Last word, Mr. Go ahead, sir.
The windows are tinted. There's no one testified you can look through that car with doors closed and see what's in it, so there's no foundation based on that.
All right. These two photographs, 1 and 3, are admitted over objection. They show the bruising on the child and further shows the condition at the time of the discovery of the child. They're admitted over objection.
Thank you.
And we'll take 5 minutes and we'll proceed. You may step down for a few minutes.
Okay, I had Zoe with us just a minute ago, but she she climbed down very ungracefully. Do you want back up? No? You want to go out? Want to go out? Zoe's here, which is good. This is Zoe said no. Absolutely. You're starting to hear this case being laid out, and it's a tough one. It's disturbing. I will say this as a parent, just the number of times that truly accidentally and for stupid reasons, kids get left in cars. We see the news stories every single year, unfortunately, that somebody was taking the kid to school who normally doesn't, and the kid fell asleep in the car and they forgot, and they went about their normal schedule, and next thing you know, they're like, oh crap, and it's horrible. It's horrible. It's horrible, and it's an awful way to die, and it's incredible. Okay, hate that. It's one of my fears as a parent, especially moving to areas that are hot. I would rather have my car ruined by having rain come in the windows, by always having the windows down, than keep the windows up and risk the temperatures going up through in case my kid just happened to get in the car. This case, the state is saying it wasn't an accident, which makes it even worse. It makes it even worse. So they're trying to prove not only that this was on purpose, but that this was a conspiracy to commit murder. This is a very high bar. So I realize as extreme as this is, the case has a very high benchmark that they need to reach with the jury to prove that there was a conspiracy. These two conspired to kill this child. And honestly, I'm surprised the state went for that conspiracy charge. Parents were on drugs. Methamphetamines apparently was the drug of choice. But the pictures are extremely graphic. They're horrible to look at. We've seen just glances of them sideways. Hopefully we won't see the whole picture. I don't think anyone needs to see it. I mean, I'm not going to judge you for doing that, but at the same time, membership for Zoe, please. For Zoe, please. Yeah, we'll have to. Zoe's like an honorary member. She likes to lay down next to the wheels on my chair, so I have to be very careful when Zoe's here. Let's see. The objection counter's up to 7 right now. I think one of them was from the judge. We're going to count that. We're going to count objections from both sides as they go through the trial. I think it will be spicy. We just realized we have three teams at play plus the judge, so technically 4 people that can object, or 4 different areas that can object. Both the defendants each have their own lawyer, so you'll hear questioning. It will look a little different, and it's one of the reasons why I like this case. One of the few reasons why I like this case. Newman is one, and the fact that we have 2 co-defendants is the other. You're going to hear cross-examination from 2 defendants and 1 prosecutor. So it's going to look a little funny. The timing, it'll seem like we're rehashing things, and I'm not sure if these 2 are going to throw each other under the bus or point the finger at the other person. I think that'll be interesting as well. Okay. My car reminds me to look in the back seat as soon as I open the door. I laugh. My kids are grown, but it's sad that a parent needs that reminder. The thing that scares me, Linda, is I've gotten in my car and had a child sneak into the car because they wanted to come with me, and not known they were in there. And until I start driving, and that scares me to death when a kid jumps out. It's like the boogeyman, appearing in the back of the car. It's no good. Well, it wasn't good, but not fun. And so if they had stayed hidden, if my child had stayed hidden and just been like, I'm going to hide until we get there, and had fallen asleep, as kids do when they hide, I could be in a very similar situation. Obviously not intentional, but a very similar situation. Sounds like the guy's defense attorney said they have 2 different stories. The jury's going to have a lot of exercise. They do. The jury gets excused. The one thing I don't like about Judge Newman, that I wish he would assert a little more, he does say, "This is my courthouse. Okay, I'm running this show. This is what we're going to do." Zoe, are you looking for a way out? Because that's not it over there. I mean, feel free to explore, but do you want me to open the door? Hang on one second. I don't know. She's just exploring. Anyway, the one thing I don't like that Judge Newman does is he lets lawyers push him around as far as the jury. They get to call and say, we need a break, whatever. Need the jury to step out for a little bit. I wish he'd assert himself a little bit more. Most other courtrooms, the judge determines if they need a break, and says, no, you keep going. We'll address that later. And in this case, the juries tend to drive that portion of the trial. If a child can sneak in, they can get out. Yes, but in a hot car, if they fall asleep, if a child falls asleep in a hot car, they can't get out. Oftentimes, the very fact that they're in a hot area makes them lethargic, makes them sleepy, makes them stay there until they're physically not able to act. It's scary. Did I hear there's video evidence from the neighbors? Connie, yes. The Ring door cam across the street is going to be featured prominently in this. That's how they know the time frame, the 5 hours and 40 minutes. Anyway, is Zoe new? New to me. She's not my dog, but she belongs to my business partner who's working on the Airbnb out there. And so Zoe gets to come inside while he's out there working. Zoe has not seen any big bugs. Zoe does chase little bugs. She chases flies and catches them and then shows you that she caught a fly. She doesn't eat them. She just catches them and then spits them out. Let's see. My brother and I were playing in our car, and our brother put the car in neutral and rolled it down the driveway and missed our neighbor's car by inches. Never saw my dad run so fast. My little brother and his friend got in my grandpa's truck when it was at our house and put it in neutral and rolled it across the street and into the neighbor's tree. I remember that. What is the 7 for? Bill, the 7 is the number of objections we've had since the opening statements began. We're going to, with the number of parties involved, I think there will be a lot of objections. Sometimes there's a double objection. I'm only going to count that one time. So if both defendants' lawyers object, that's going to be one objection. So basically for each interruption caused by an objection, we're going to count that. wait for the surveillance video, then decide if this was an accident. I don't believe this is an accident. It sounds like the evidence shows contrary. Let's see. My sister's cat licks all the dust on the baseboards. Anything low? Your cat eats dust? Her cat eats dust. That is, I mean, that's a useful cat. You could rent that out. I could, but I like the engagement. Red pen. No, the problem is the device I'm using allows me to put 2 overlays on pretty easily, and I've got 2 right now. I've got me and, well, I've got 3. I've got the words, my face, and
so
the
listen,
objection
regarding
counter.
these exhibits, I typically like to get copies of the exhibits before they're being offered, not as they're being offered, because I don't want to stop the testimony to look at the exhibits, to evaluate it if I have them. You all have them. I assume you've shared a lot of them with the defense. And you don't have to do it now, but you have some time to make photocopies of them. I don't need the color copies, just I want to be able to follow things.
I did it right.
All right.
So here is the list we have so far up through 12, and we marked on the very back the exhibit.
All right. Thank you.
Yes, sir.
All right. Let's bring the jury.
Sorry.
In addition to the fact that I can't see around, I'm surprised you said you could see it.
If I lean forward, I can.
Hey, Thomas, is this, how many hours of motion is it looped through? Could it be more motion on the loop, or is it just current view? Looks good, looks good. Okay, I'll pull that up in a second. I'm trying to build something around it. So we are doing a lot of work on the audio stream here. This courtroom is really bad for audio, and the mics are not being utilized properly. So I'm doing everything I can to try to draw out the voices.
Thank you, Your Honor. Ladies and gentlemen, let me hand you what has been marked as State's Exhibit. Two, 3, 4, and 1. First of all, let me just ask if you recognize those photographs.
Yes, sir.
Are those fair and accurate depictions of the scene as you saw them that day?
Yes, sir.
At this time, Your Honor, we move State's Exhibit 1, 2, 3, and 4 into evidence.
They're admitted on objection.
Thank you.
I'll first call your attention to the monitor, Your Honor. I've got to be smart, but I also have them on the monitor. Let me go first to State's Exhibit 2. I think I have that so everybody can see. Tell me what this photograph is depicting.
This is what I saw when I got on scene, as far as where Christina was. Also the vehicle, the Volkswagen was parked just as it is there.
Now, when you say Christina, did you know her? Or did you just learn her name later, or did you know her name?
I knew of her previously.
Okay, so you knew her name. So when you...
Pardon?
Objection.
Basis for the objection.
There's no foundation for that, and it's highly privileged.
Objection is overruled.
Thank you. So when you say Christina, you know that's who that is?
Yes, sir.
Okay. Let me go now to State's Exhibit 4. Tell me what's depicted in that.
Again, it's another picture of Christina laying in the overgrown grass.
State's Exhibit 1. Is that a fair and accurate depiction as you saw it that day?
It is.
And tell me what that depicts.
Also Christina's body after it had been rolled over.
And then State's Exhibit 3. Tell us what those are.
Blisters on her skin, which is showing down to her raw skin.
We go back, if I could, to State's Exhibit 2. Now, where are you when you walk up on this scene? And I know we had a photograph earlier that we put in for the overall scene as you were walking up. Where are you standing at this part?
As I walk onto the scene?
Yes.
It would have been in the direction of the jury box.
Okay. And where is Larry King?
To the left.
And where is Rita Pangling?
Inside the residence.
At some point then, did you go and get Rita Pangling out of the house?
I did.
And where was she when you went in?
She was just beyond the living room, pacing around inside the house.
Did you bring her outside?
I did.
Did she tell you what happened?
She did.
What did she say? Or excuse me, did she tell you? What did she tell you happened?
She told me that she put Christina in the car and went back inside to get cigarettes, and when she came back, the doors were locked.
The doors were locked. What?
On the vehicle that Christina was in.
Let me ask you one other thing too. When you got to the scene, what was it like outside? What was the temperature?
I don't know the exact temperature, but it was extremely hot. It was August in South Carolina.
The car itself, and I think we have that in State's Exhibit. Let me see if I can see this one. State's Exhibit 5. Put that up on the monitor. Where is the car located as to any type of shade, anything like that?
It was not in any type of shade. When I arrived on scene, it was in the open sun exposure.
I don't have any further questions. Answer any questions.
Yes, sir. Hallie Godley?
Godley?
Yes, sir.
Agent Godley?
Yes, sir.
Agent Godley, did you also have the opportunity to speak with Mr. King on the scene that day?
I did.
And how would you describe his emotional state when you spoke with him?
He seemed a little panicked.
He seemed upset?
I took it more as a panic, more so than an upset.
Was he still on the phone with 911 when you spoke with him?
Yes, sir.
So there's a recording of what was taking place that we could listen to some other time. I suppose 911 calls are generally recorded. You know that in your work, right?
Yes, sir.
Did you ask him what happened?
I don't recall. Yes, sir.
Thank you. Agent Godley, you said when you arrived, Rita was inside?
Yes, sir.
Were you aware that Rita's the one who got her out of the car?
At that time, no, sir.
But you do know that to be true?
Correct.
Right. And as far as that point, you weren't there after she gets her out of the car, and you didn't observe the way she acted after finding the body, is that?
That's correct.
No further questions, Your Honor.
That's all this time, Your Honor. State Call Charles Jones.
You may step down.
Wow, they called the next witness while one was still on the stand. Usually they give the judge a chance to release the witness. Both are on trial at the same time.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Take a seat in the witness stand. State your name again for the record. Spell your last name.
Charles Jones, Jones.
Mr. Jones, what do you do, sir?
I'm a firefighter paramedic for Collin County Fire Rescue.
And how long have you been a firefighter paramedic? Is that, by the way, is that a combined job?
Yes.
Okay. So how long have you been at that job?
This November I'm at 6 years, I believe.
Now, when you, as a paramedic, what does that? I know there's some tiers of emergency medicine. What is how does the paramedic rank?
You have your EMT basic, your advanced EMT, and then your paramedic.
So, as a paramedic, can you assess whether or not somebody is alive, dead?
Yes.
And you have some equipment and things like this that you
Yes.
use? You were called to 685 Low Country Highway on August the 5th, 2019, were you not?
Yes.
Tell me what you found when you got there.
The child laying prone with her legs kind of extended a little bit, a few feet from the rear passenger or rear driver's side of the vehicle on the ground. Didn't appear to be breathing or have a pulse.
I'm sorry, I didn't understand.
Didn't appear to be breathing or have a pulse.
Did you check for any of that?
Yes, we applied the cardiac monitor, which showed what's called an asystole rhythm, which means there's no heartbeat at that time.
All right, so when you apply cardiac, how do you do that?
We apply 4 leads on the person's body.
Are these the little white things?
Yes, yes.
So did you apply those 4 leads on
Yes.
Christina's body?
Yes.
And did you check that with the monitor?
Yes.
And what were the results of that?
It showed the asystole rhythm, which is no electric activity or heartbeat.
So what does that mean?
That the party's deceased.
No further questions this time. No, Your Honor. No questions.
All right, thank you, sir.
Thank you.
State called Scott Sheck.
No questions from either side of the defense. Copy machines in use right there.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court shall be the truth, so help you God?
Yes, ma'am.
You can see the witness stand. State your name again for the record. Spell your last name.
Yes, ma'am. Todd Shank, Schenk.
He's loud.
Mr. Shank, what do you do, sir?
I'm a crime scene investigator for the South Carolina Law Enforcement Division.
And how long have you been doing that?
What kind of investigation?
crime scene investigator.
Sorry. I've been doing crime scene investigations for almost 10 years now.
And all that time with SLED, with the State Law Enforcement Division?
Yes, sir.
And so in your capacity as a crime scene investigator, what do you do?
So our job at SLED is to respond and give forensics expertise to our counterparts at the local, county, or municipality level. So we show up, we'll document their crime scenes with photos, collect evidence, give any kind of scientific help we can in the forensics field to our local counterparts.
All right, so you are collecting evidence, but at the scene you're collecting it through the case?
We are, yes.
Let me first go to State's Exhibit 8. Your Honor, I believe I marked it on the back of that copy of the State's Exhibit. This is the crime scene sketch. All right. Let me show you what's been marked as State's Exhibit 8. Is this your crime scene diagram?
It is.
Right. And this is the one you prepared after responding to this scene?
Yes.
This time, Your Honor, we move State's Exhibit 8 into evidence.
It's admitted without objection.
And I know it's difficult for Your Honor to see the copy, but I'll use it off this. If you would show the jury, can you see it from there? I'm trying to find a place I can locate it where it don't block the defense counsel. Can you see it from there?
Yes, sir, I can.
All right. Can you explain to the jury what that is, please?
Yes, sir. So this is the residence at 11685 Low Country Highway. The residence right here is, may I step down?
Yes, sir.
So this box right here is the actual residence itself. This would be the front door. This next box is just the porch, the very basic version of it with the columns. This is the Jetta, Volkswagen Jetta that's parked out front. The victim was located here. There's a small sidewalk, and then this was the blue Chevy pickup truck that was out front. The main road would be down here.
And so that corresponds actually with this corresponds basically with State's Exhibit 5. Is that correct? And that's already been admitted into evidence?
Yes, sir, it does.
As you are, if you go through this, did you, in this scene, not only did you do this graph, did you also inventory the car, the automobile?
We did search it and go through it. Yes, sir, we did.
And as you inventory the car, do you ever move things around? Do you record it, photograph it? How do you I guess, document the scene, so to speak?
So first thing is photographs are our biggest documentation tool. My partner in this instance documented the scene with our photographs. We take overall, mid-range, and close-up photographs to establish where things are in the scene. I'll also handwrite notes. We'll take measurements. So there's multiple ways in which we document a crime scene, but photos being the number one.
Let me show you one other exhibit too. This is State's Exhibit 6. Now, I do not believe I had a copy on that one. This is just an aerial view of this. Let me show you on State's Exhibit 6 that this is a fair and accurate depiction of how the car was located on that day.
Yes, sir.
Okay. And Your Honor, this time we move State's Exhibit 6 into evidence.
It's admitted.
Okay. Let's try to can you show that on the screen? All right. And that is where the car was located. That's sort of an aerial view of basically of your crime scene chart.
Yes, sir.
Okay. All right.
I'm going to turn off the closed caption here in just a minute. I want to get a little break.
Your Honor, may we approach?
Yes, sir.
No. They're approaching right now. Do we count this as an objection? Do we count the objection here? They're going to discuss this. Sidebar. He's like, what are you doing over there? Okay, so give me a second while they're talking this over. I'm going to turn off the closed captioning. It usually gets it wrong anyway. Sometimes that's entertaining, but it also gets in the way of our messages. Man, pickles gave me the hiccups. I'm eating these freshly acquired spicy maple bourbon pickles. They don't sponsor the program, but they should. They're really, really good. Yes, sidebars are objections. Do we want to count this? Or just want to count the number of time we hear objection? There's no conserving pickles. There's just buying more. Yes. It's feeding my addiction. There's no stockpiling. It's just everything is on hand for current use and consumption. Mr. Electric, we're keeping a close eye while this goes on. We're watching, thanks to Weather Watch, we're keeping an eye on his channel. He has a live feed going up with the radar. If you want to watch the track of the storm and where that's at, we can keep an eye on that. Thank you, Thomas, for that. Great podcast host and weatherman. It's like having our own private weatherman. I think Zoe's gone. The kids like to tempt her away with food, so we'll see what happens.
Right, let me show you first what's been marked as State's Exhibit number 9, State's Exhibit number 10, 11, and 12. First, if you could tell me, can you identify those photographs?
Yes, sir, I can.
And are those fair and accurate depictions of how the back seat of that car looked when you and your team inventoried it?
Yes.
And those are fair and accurate depictions of what's in that bag and as the bag being opened, the whole bit?
Yes.
Okay. At this time, Your Honor, we move State's Exhibit 9, 10, 11, and 12 into evidence. Subject to the ruling under objection to 4.43.
They're admitted over objection of...
Thank you, Your Honor. Let me first show you on the monitor State's Exhibit number 9.
Yaku, I don't know if there is...
Now, can you describe for us what that is? I know it might be kind of hard to see from here. Can you see it well?
Yes, sir, I can.
Okay, if you could describe for the jury what that is.
So this is looking in the rear passenger door of the Jetta. So the front passenger is the seat on the top right of the photo. This would be the... Go ahead, sorry.
And I'm going to stop you there. This bright spot right here, what is that?
That is the open door on the driver's side of the back.
All right, and so that is in the same condition as the crime scene that we showed earlier, which is State's Exhibit 5 that the door's open.
Yes, sir, it is.
Okay, so you're now on the other side of this car, which would be, go back to the file, please. Back up here?
Correct.
Is that correct?
Yes.
Okay. All right. If you go back to State's Exhibit 9. All right, so in that back seat, tell us what that is.
So there's a blue duffel bag, some kind of gym bag sitting on the rear passenger seat. There was a pink sippy cup in the middle of the car, or the middle of the seat, and then some other items down there on the floorboards.
And the bag, is that in the condition that you saw it when you got there?
It is.
Let me go to State's Exhibit 10. Describe what that is, please.
That is a 9mm handgun that had 2 different barrels on it.
And that was in the top of that bag?
It was.
The hand on the left, is that one of your team members or your team?
That's my photographer spreading the bag so you can see the handgun.
And then let me show you State's Exhibit number 11. Tell us what that is.
That's showing that there are 2 cartridges in each, or a cartridge in each chamber of the handgun.
Okay, when you say cartridge, what do you mean?
It's the unfired bullet. So the bullet
It's loaded.
It's loaded, yes.
And then finally, let me show you State's Exhibit 12. What's that?
That was a Tupperware full of cigarettes in the bag.
Okay. And that's all in the back seat of the car?
Correct.
I may approach her and hand this up.
Yeah, I wasn't expecting the Tupperware full of cigarettes either. Double barrel pistol, a 9mm. I'll have to look this up. I wish they'd tell me what the make was. Do a quick Google search. I'm sure I can find it.
All right, let me show you what's been marked as State's Exhibit 29. And I'll hand these at you, and I'll just ask you to hold on to them for right now, please. 30, 31, 32, 25, 26, 27, and 28. Are those fair and accurate depictions of what is shown in those photographs?
It is.
And what are those?
These are tubes of blood that I collected via chain of custody from the Colleton County Sheriff's Office.
Okay. And what did you do with the, and before you get into that, these other tubes, tubes of blood would be referenced in 27 and 28. What about these other photographs?
These are photographs showing the container and how I sealed them and submitted them into the lab.
Okay. At this time, Your Honor, we introduce these photographs into evidence. State's Exhibit 29, 30, 31, 32, 25, 26, 27, and 28.
Tag, you've got the yellow courthouse. I think you've had it for a little bit, though. Thank you very much. Welcome.
Can you repeat that, please?
I object to their introduction at this time. I do not believe the foundation has been taken. Prior objections.
Objection, foundation,
They'll
objection,
be
prior
marked
objections.
for ID purposes at this time.
Okay. So let me ask you, first of all, when you took the blood, what did you do with it? First of all, the blood vials, where are the blood vials coming from?
I believe it was Investigator Kelly Paget, or investigator with the Colleton County Sheriff's Office.
Okay, from the Sheriff's Office.
Correct.
Okay. Did you get all of the blood vials from her?
I did.
All right. When you received those, are those blood vials concerning, I think we've got, read them. Do you know where the blood came from?
It came from our two suspects.
Okay. Larry King and Rita Pegler?
Yes, sir.
And these blood vials, what did you do with them once you received them?
So once I get them, I transport them back to Columbia to the forensics lab. I seal them in a heat seal pouch, log them in, and submit them so they can be disseminated.
So you actually put them in the best evidence bag that's left?
The heat seal, yes, sir, I did.
Okay. How did you receive? Did you receive them as is depicted in, I guess it states Exhibit 27?
Yes, sir. I got them in it was a sandwich bag or some kind of Ziploc bag from the hospital.
And these numbers on there, what do those numbers indicate?
That's the lab number, item number, and my initials.
Okay. And so that's your initials there?
Correct.
Right. And then this other paperwork on what I just referred to as the best evidence bags. This is what you actually produced. Is that correct?
It is.
All right. And what's the purpose of those? And specifically, that is in State's Exhibit number 30 and State's Exhibit number 29.
They're
the purpose of that?
Tamper-evident bags where it's a plastic bag that we use a heat sealer to seal the top and we initial and date the seal. And that just shows that if someone were to try to access that evidence, they would have to destroy the seal to get to it. So it's a way of sealing it.
So your taking of the blood, did you change or alter the blood of either Rita Pengelangen or Larry King in any way?
No, sir.
Your process was as a chain of custody, which takes it from one person to another?
Yes.
And in that process, you put them in these best evidence bags, which are indicated in these photographs?
Yes.
Did you change or alter what was inside of that in any way, shape, or form?
No.
And the writing on State's Exhibit 25, 26, actually 31 as well, 29, 30, and 27, all that writing on there indicated on that is stuff that you did, you prepared.
I did.
As a part of the chain of custody.
I did.
Okay. And again, you did not alter it or change it in any way?
No.
Your Honor, this time we do this exhibits into evidence.
I can rule on each individually if you prefer.
Subject to the prior objections that we have.
Excuse me.
Related to toxicology.
Number 25 is admitted. Number 26 is admitted. Number 27 is for ID purposes only at this time, as well as 28. 29 is admitted. 30 is admitted. 31 and 32 are for ID purposes only at this time.
So for ID purposes only, 27, 32, 31, is that correct? And 28, I think, is also ID.
27, 28, 31, and 32 are for ID purposes only at this time.
Let me go to State's Exhibit 30, please. Okay, and this is the best evidence bag you were describing?
It's our heat seal pouch, yes, sir.
All right. Yeah, what is the purpose of that?
This is a plastic bag that we heat seal the top, and it is a tamper evident bag where if someone were to rip it open or try to gain access to the evidence, it would be readily visible. So it's just a way of protecting the evidence as it's transported throughout the lab.
And the handwriting on that is yours?
It is.
Go to State's Exhibit 29. Again, what is that?
This is the this is the item for heat seal pouch. And at the top, you can see where I've initialed and dated the seal, and you can see the crease in the plastic.
Now, the yellow sticker, what is that?
That is our barcode system. That's how we can electronically transfer evidence throughout the lab. So it's an electronic chain of custody.
And then State's Exhibit 26.
This is item 6, heat seal pouch.
And State's Exhibit 25.
This is showing the initials and date on the actual seal where I sealed it on item 6.
And the purpose of you sealing it at that point, once you seal it, what do you do with it?
I then submit it to our evidence process or our evidence control, who will then disseminate it throughout the lab to where it needs to go.
In your lab, and we talked about you being a crime scene investigator. Tell me about what type of lab are you talking about when you say lab?
It's a forensics the South Carolina Law Enforcement Forensic Services Laboratory. So we do everything from crime scene to firearms, latent prints, DNA, trace, tox, any forensic evidence, any kind of forensic science that we need to do, we do.
And so when you say tox, what do you mean?
Our toxicology department, they can look at blood, and it's best for a tox to tell you exactly what they do. But we have scientists that work in the building and can work in their discipline.
Okay, so all of these items here, you took that to the lab and turned it over to them, is that correct?
I did.
And again, did you change or alter it in any way before you did that?
No.
Thank you, Your Honor. Any further questions at this time?
By the defense.
I've got no questions for you, Shane. Thank you. No further questions.
Thank you.
Thanks, sir.
I've almost gone through my first jar of pickles today. There's a little bit left. A little bit.
State House Lindsay Lewis to stand.
We saved your spot for you, Tag. Good to have you back.
Your Honor, of course, this is subject to fire.
Yes, sir.
I wish he wouldn't have to say that all the time, but he just objected again. Subject to prior objection. They're objecting to every piece of evidence.
Raise your right hand. Left hand. Do you affirm the testimony about the given before in this trial shall be the truth, so help you God? If they can see them with the same, say your name again for the record. Spell your last name.
Lindsay Lewis. Lewis.
All right, let's get you to pull the microphone close to you, please, ma'am. All right, and go ahead and tell the jury your name again.
Lindsay
And last name?
Lewis, Lewis.
I think this is the neighbor across the street.
St. George now.
St. George, Utah.
St. George.
About a year.
Where did you live prior to that?
Walterboro.
And how long did you live in Walterboro?
Wow, a while.
How old are you now?
I am 22.
Let me ask you to go back
Is it St. George, South Carolina?
Second.
Is that a thing?
2019. How old were you on August the 2nd, 2019?
18.
Did you know Rita Pangolin?
Yes, sir.
And how did you know her?
She was my child development teacher.
And what school was that?
Colleton.
Now, on August the 2nd, did you have a reason to go to Rita Pangolin's home?
Yes, sir.
And what was that reason?
To meet to go over her daughter Christina's routine, about her everyday living and all that stuff, taking care of her.
Why did you do that?
Because I was going to be watching Christina. I was supposed to watch Christina.
Did you have any particular interest in this? How did this come about?
Because I was going to be a nurse, so they thought it would be best for me to, kind of get the hang of her routine and all that. It might help me out, so I agreed, and that's when I went.
When you say they, who are you talking about?
Rita,
okay.
And I think she spoke to my mother about it.
Okay. And so, did you go over to Rita's house for the purpose of learning how to take care of Christina?
Yes, sir.
Copy for your honor. Let me show you a picture of, State's Exhibit 13. First, I asked if you could identify that. Is that a fair and accurate depiction of how Christine looked?
Yes, sir. Yes, sir.
And that was when you knew her when you were 18, is that correct?
Yes, sir.
And again, that is we're talking about August the 2nd, 2019.
Yes, sir.
Okay. At this point, Your Honor, we're moving into State's Exhibit 13. No objection, Your Honor. No objection.
It's admitted.
If you could go to State's Exhibit 13. All right, now, as you knew Christine, first of all, tell me about her. She appears to be in a wheelchair. When you were dealing with her at the house, tell me about her. Could she walk?
No, sir.
How did she get around?
She would crawl or on her knees, or either on her hands. Kind of like a baby.
I apologize. I didn't interrupt you. Go ahead. I'm sorry.
Kind of like a baby, sort of.
Okay. And her hands, especially on the right, looks like, can she fully grasp things?
No, sir.
What about her ability to talk? Was she verbal?
No, sir. She would babble maybe, but she couldn't speak full words like, we can.
And tell me, from the standpoint, it looks like she's actually smiling in that picture. Could she show emotion?
Yes, sir.
And this is, and you went over there on August the 2nd to learn how to take care of her?
Yes, sir, pretty much.
What was involved in that, in taking care of Christina?
She has to get, certain baths, and you have to change her, and, stuff like that.
When you say
Feed
change
her.
her, when you change her, what do you mean?
Like her diaper, I guess you say pamper, or whatever you want to call it.
On August the 5th, there's actually a photograph of her in a diaper. Is that the condition she was always in?
Mm-hmm.
And I need to say yes or no?
Yes, sir.
Okay. And so you had to change your diaper. What type of food did you give her?
I was told to give her Ensure nutrition drinks.
Anything else other than that?
No, not at the time.
All right, so you go over there on the second with the idea of learning how to take care of her. What happens after that? About what time do you get there, by the way?
I believe it was about noon. Noon, 1 o'clock maybe.
All right, so what happens after that?
Well, I just got there and we went over the routine pretty much, and then Rita asked me if I would watch Christina while she went on a date with Larry.
Was that Larry King?
Yes, sir, her boyfriend. As of my understanding.
What time did she ask you to go, if you would watch her?
What time?
Yes, in other words, you got there about noon, you went through the care. About what time did she ask if you'd watch her?
I believe it was like around 5, 6 o'clock.
Okay. And did she?
Yes, sir.
Okay. And tell me about that. She left the house, I'm assuming, sometime around that afternoon?
Yes, sir. I would say about like around 5, 6 o'clock. That afternoon, she left.
Was anybody else there to take care of Christina?
No, sir.
It was just you?
Mm-hmm.
Had you taken care of Christina before?
No, sir.
This was on what day?
The second.
August the 2nd.
Yes, sir.
What day was that?
A Friday.
Did you see Rita Pangolin again?
Not until Sunday afternoon.
After she went on a date with Larry, did she say, I'm gone and I'll be back Monday or anything like that?
She said that she texted me later that night to check on Christina. I would say about 9:30, 10 o'clock. And then she said she would be back the next morning on Saturday to go grocery shopping and stuff like that, but she never came. And
were there groceries in the house?
No, sir.
Just the insured drinks?
Mm-hmm. And I think there was a pitcher of Kool-Aid in there, maybe in the fridge.
Right. So did she come back the next day? That
No,
would be,
sir.
I guess, the
Saturday.
Saturday, correct?
Mm-hmm. Saturday.
Did she come back Saturday?
Mm-mm. No, sir.
Did she call in?
No, sir.
Were you able to get in touch with her?
Through Facebook, I think it was.
I'm sorry?
Through Facebook, I think it was.
Did you talk to her again Rita, after that?
After Saturday?
Yes.
Not until Sunday. When she said that she would be, that Larry would drive her back to the house because she did not know how to drive his truck, and that he got sick with food poisoning. So that's why she was gone taking care of him.
At any point in time, did she call to ask if it was okay if you took care of the child?
No, sir.
Didn't hear from her after she called to check in Friday night?
No, sir.
Did you ever, by the way, did you see Larry later on?
Later on, when?
The next day?
Mm-mm. On Saturday? No, sir.
Sunday?
Sunday? No, sir. I know he was out there. I could hear music or something. I know somebody was out there. And I'm guessing it was him dropping her off.
Yes. I was wrong. My real question was, did you ever find out if he was actually sick?
Sick? No.
No what?
No, sir. I did not find out if he was actually sick.
Okay. And then, when did you, in fact, see Rita again?
Again, when? Oh, that would be Sunday.
Okay. Sunday, about what time was that?
Then the afternoon. I would say 5, 6 o'clock maybe.
Tell me also, did you also put the child to bed? Did you also put Christina to bed?
Mm-hmm. Yes, sir.
Did you see anything unusual?
Yes, sir, I did.
What was that?
I came later to find out it was bed bugs.
What section you're on? 401, 403, 404. All previously given to your honor and both defense and already argued.
Right.
All that was in the statement, and all of that is already discussed. Argued.
Not overrule the objection.
Thank you.
Wow.
Please answer any questions the defense has. Thank you.
Where are you going, ma'am?
Oh, I don't know.
Pardon?
Sorry, I didn't know what he was saying.
She wants out.
Good morning.
Good morning.
You knew Christina from before, correct?
Yes, in the classroom.
Right. Rita would bring Christina to the classroom.
Yes, sir.
And when they're in the classroom, they were having fun. You had fun in the classroom?
I guess so, yeah.
Everybody seemed safe in the classroom?
Yeah.
There was no
Yes, sir.
concerns when she would bring Christina with her to school.
No, sir, I'm not sure.
And she taught you? Rita did?
Yeah, for a little period of time.
And you felt comfortable enough with her as your teacher that you wanted to help, potentially, from becoming a nurse, to help take care of her child?
Yes, at the time.
And were you aware that through her condition with, as far as the pediatrician, that she had a choking hazard, that she had to drink Pediasure or pureed food? Did you know that?
That she had a choking hazard?
In other words, she couldn't eat cold food.
No, I did not know that at the time. I was just told she was supposed to drink Ensures
And there were boxes of those in the home.
in the pantry.
Right, there were plenty of those.
Yeah, there's a few.
At that point, Rita texted you to say that she was checking in, but you said you didn't hear back from her.
At what point?
Did you call anyone about that?
Call anyone?
Yes.
You said?
Did you call anyone about not hearing from Rita?
No. Did I call anyone about not hearing from her? No.
And why is that?
I just figured she'd be back. I mean,
Because you felt comfortable. You had control of the situation.
at the time,
You did, didn't you?
I was a little confused, but yeah, I mean,
And you were taking good care of Christine?
yeah.
No further question, John. Just one very briefly. Did Rita tell you, by the way, that she couldn't be given solid foods because she choked to death?
She did not tell me that. All she told me was not to give her Ensures. That's what she told me.
Nothing else, John.
Anything further?
Thank you. State College Bridge.
Let's have a witness on the stand.
Your Honor, I guess before we go down that road, I guess we can do that. I'll have.
Do you have any additional questions of this witness?
No, Your Honor.
All right, you may step down.
Okay, thank you.
State College Bridge in Honeycutt.
The mom, Rita, won Teacher of the Year. She was a teacher. Mrs. Ari wins that award every year at her school. Every year. She also wins Principal of the Year and Scheduler of the Year, Secretary of the Year. She wins all the awards.
Raise your right hand, left hand on the Bible. You affirm the testimony about the word of the Lord in which God shall be the truth, so help you God. You can see the liberty stand. State your name again for the record. Spell your last name, please.
My name is Brittany Honeycutt, Honeycutt, Honeycutt.
Miss Honeycutt, where do you live, ma'am?
I live in Lake City, Texas.
And what do you do?
I am in administration for Chevron.
How long have you been doing that?
A couple months.
Let me ask you to go back now to August and a few months prior to that, in 2019. Did you know Rita Pangalangan?
I did not know her personally. I met her through an ex-boyfriend.
Okay. And so, did you have an occasion to come in contact with her on a regular basis?
After I moved in, yes.
All right, but tell me about moving in.
When I moved in, the agreement was I would pay some rent.
All right, let me back up just a second.
Okay, sorry.
So, who are you moving in with?
Oh, it was me and my two kids.
Okay. And who are you moving, you and your two kids, in?
Into Rita Pangaling's house on Academy Road.
And that's Academy Road?
Yes, I think so, yeah.
All right, great. So,
What was the rental agreement on that?
I would pay her some rent just for staying there because it was supposed to be a temporary situation.
How long did you stay, how long did you rent from Rita?
From May of 2019 until August 1st of 2019.
Until August 1st, 2019. So until the Thursday before this.
Yes.
During that time, did you come in contact with Christina?
Yes, every day.
Tell me about Christina. How would you describe Christina?
Christina was obviously disabled, but she was a sweet girl. She was quiet. She kind of watched TV. She played with her toys. She didn't really bother anybody. I mean, you knew she was there, but she was just really quiet.
Tell me, could she walk?
She could not walk.
Could she talk?
She could not talk.
But you could see emotions, I guess. From
Oh yeah, she definitely showed emotions.
Okay. Did you ever take care of Christina?
There were a couple times where I was asked to watch her for a little bit.
So when you say you were asked, who asked you?
Rita asked me.
Okay. Asked you to watch her?
To watch her, yes.
And how many times was that?
By myself, a couple.
Your Honor, this is subject to our prior.
Yes. Yes. Proceed.
Thank you. All right, so over the time that you stayed there, you watched her yourself, by yourself a couple of times?
Yes.
And what did you have to do to take care of her?
Since it was just a few hours when I had to do it by myself, it was just basically make sure her diaper was clean, make sure she had Kool-Aid in her cup, and that was pretty much it.
Did she, did Rita Pangline ever just leave the child with you without asking you to take care of her?
Yes.
And how did that happen?
So there was an incident where there was a Sunday night in July where she had asked me to watch her for just overnight, and I said that was fine. So, I'm sorry, that was not Sunday, that was a Monday.
Okay.
And she came back the next day because I had told her I had to work. So she did come back home that morning, and she told me she was going to be home all day. And when I was ready to go to work, sorry, I am so sorry. I have got my days mixed up. So when I first watched her the first night, that was an agreement. The next day it was she wasn't going anywhere. And then it was I remember her giving her a bath. I remember her getting ready for bed, and she would close her door, and she did the normal routine. And then I went to bed with my kids because I had to work the next day. And next thing I know, the next morning I woke up, Christina was in her room trying to get out of the room.
So when Christina's in the room, is she locked in the room?
I don't know if the door was locked, but I know she could not open the door.
Because of the hands?
Yes.
Did Rita, and let me go now, I'm going to go right up until the August when you left. You ended up leaving the Thursday before this event took place, is that correct?
Yes.
Getting pretty close to that time, did you have a discussion with Rita about you babysitting Christina and whether or not you were able to do that?
Yes.
Please tell us about that.
So she had come up to me and asked me.
All right, I'm going to stop.
Oh, sorry. Oh, sorry. Should I just say her name?
Please.
Okay, sorry. Rita came up to me and had asked me if I could watch her. I had let her know that I had to go into work for a few hours, and she kept asking me over and over. And finally, when the answer didn't change, it was no, obviously. She told me to leave Christina in my car with the windows down because she does it all the time.
Objection is overruled.
Thank you, Your Honor. I'm sorry, I think you interrupted you. You said you couldn't because you had to go to work.
Yes.
Pick it up from there.
So when I told her the first time, she kept asking me over and over again. And when she realized that the answer was not going to change from no, she had told me that I could still take her and leave her in my car with the windows down. And because she does it all the time. Because she does it all the time.
She being?
Rita.
You see Rita Pangling in the courtroom?
Yes, I do. She's right there.
Your Honor, let the record reflect she's identified the defendant, Rita Pangling.
Right there, where?
Oh, right over here in the
What is
white
she
shirt. It looks like a blue jacket and a white shirt.
It does.
Thank you, Your Honor. No further questions. Thank you,
Okay.
sir.
Phillips.
Thank you, Your Honor. Ms. Honeycutt, Rita kicked you out of the house right before all this happened. Is that right?
It was more of I was moving. I had already had a house set up.
That's your opinion.
She kicked you out of the house because you weren't paying rent, and you brought bed bugs into her home. Is that fair to say?
No, sir.
And you also moved your boyfriend into the home with his whole family. Y'all had a very toxic relationship, and you were in her home, not paying rent, correct?
I do not agree with that, no.
No further.
Whoa.
Nothing else, John.
Thank you. Ms. Step down.
Thank you.
Wow.
State calls Kelly Paget.
In Your Honor, the matter of law.
We'll address it later.
Thank you, Your Honor.
This case is moving right along. Very low blow.
State your name again for the record. Spell your last name.
Good morning. My name is Kelly Paget, P-A-D-G-E-T-T.
Ms. Paget, who do you work for?
With the Colleton County Sheriff's Office?
All right, so would it be proper to say Deputy Paget?
Yes, sir.
Deputy Paget, were you working for the Colleton County Sheriff's Office on or about August the 5th of 2019?
Yes, I was.
And did you have an occasion to come into contact with Rita Pangling?
Yes, I did.
And at some point, did you take her to the Colleton County, what's the hospital in here in Walterboro? Is that Colleton Memorial?
Colleton Regional Center, I believe is what it's called.
So did you take her to the hospital?
Yes, I did.
And were you present when blood was collected from Rita Pangling?
Yes, I was.
And I'm going to show you what's been marked, 3 photographs that have been marked for identification, and they are states 31, 32, and 34. So first I'm going to hand you states 31 and 32. And if you would look at those 2 photographs, I realize there's some writing on that bag that you did not do. But do you recognize the vials in those photographs?
Yes, I do.
And what are those vials of?
This would have been the blood that was collected from Miss Pangalangan on the night I took her to the hospital.
And when you got that blood, did you have it in this, I'll call it a plastic bag or a Ziploc appearing bag? Did you have it in that container?
Yes, it was placed in that container by the nurse at the hospital.
And was that done in your presence?
Yes, it was.
And what did you do with that bag?
It was, I transported it back to the sheriff's office, and it was handed over to SLED crime scene unit that I met at the office.
All right. And is that Agent Shank?
Yes, Agent Shank, yes.
While you had the blood in your custody inside the Ziploc bag, did you alter it or change it in any way?
No, not at all.
And was it in the same condition as it was when the nurse took it and handed it to you?
Yes.
I'm now going to hand you what's been marked as States Exhibit 34 and ask you if you can identify that photograph.
Yes, I can.
And what is that a photograph of?
This is a picture of myself and Miss Pangalangan still at the hospital. I'm holding a form and the Ziploc bag with the vials of blood.
And is that the same vials of blood that appears in States 31 and 32?
Yes, it is.
And is that the same blood that was collected at the hospital here in Walterboro?
Yes, it was.
At this time, I'd ask that States 31, 32, and 34 be admitted into evidence.
Subject prior to. No objection, no.
Ma'am, were you there when the blood was drawn?
Yes, sir.
Did you see the blood being drawn?
Yes, sir.
Any further questions? Either side.
No, Your Honor, thank you.
It's admitted over objection.
Thank you, Your Honor. If we could, Dylan, if you would put up States 34 so that the jury can see.
Got an objection counter going in the bottom right-hand corner. Let me know if I missed one.
I know it's a silly question, but is that you in uniform?
Yes, sir.
And next to you, is that Ms. Pangling?
Yes, it is.
And then that you described earlier, your testimony was that was the bag. And I will now, Mr. Hightower, go to 31. So are those the vials of blood you mentioned earlier?
Yes, sir.
And 32. And those you can actually see the writing that indicates the printed label, whose blood it is, etc.
Yes.
And did you also receive blood from another deputy?
Yes.
And whose blood was that, as far as you know?
Taken from Mr. Larry King.
And what deputy gave that to you?
Brian Barnadoe.
And what did you do with Larry King's blood you got from Brian Barnadoe?
It was also handed over to SLED Agent Shank.
And were they the same vials or same type of vials that we have just seen in these other photographs?
Yes, sir.
Agent Shank. That is an awesome name.
Court's indulgence, please.
Cachette got the blue wrench.
Any other questions? Please answer any questions defense counsel has.
I have none, thank you. No questions, Your Honor.
All right, thank you.
Thank you.
Cachette got the blue wrench. She helps us out with some of the editing of specifically shorts.
I'm sorry, I apologize, Judge. State called Spencer Stevens.
So I'll stand for a moment waiting on him.
Need some good yoga music to play. Okay, I ate almost the entire jar of pickles. Probably the stress of this trial. But oh man! So now I'm having a sparkling strawberry lemonade. Let's see how that goes with the pickles. We are moving through the witnesses. What was that, number 5? The defense is not arguing the facts, the factual stuff. No, Ashley, those are an abomination and not for human consumption. I can't
Spencer Stevens. Last name is Stevens.
Spencer Stevens. No, I got the last 2 jars of pickles off the shelf yesterday in Walmart. $2.84. They're on sale right now. Got a roll back.
Your Honor, I apologize. I didn't pass the other one up. I'll pass up copies. Thank you, sir. Mr. Stevens, where do you work, sir?
Right now I work at Roper St. Francis.
All right. And back in August the 5th of 2019, were you working at Roper St. Francis or somewhere different?
I worked at Colin Medical Center at that time.
All right, so in what position were you working?
I'm a nurse in the emergency department.
Let me give him a little more bottom end on his voice. Hold on 1 second.
Did you draw blood from Larry King?
Yes.
I'm going to hand you what's been marked for identification as states 27 and 28 and ask you if you can identify what's in those photographs, specifically the vials.
They're different vials we use for different lab studies. Some are for coagulation, some are for chemistry, some are for a basic chemistry panel.
And do those have markings on them that allow you to identify them?
Correct. When a patient comes in the emergency department, they're registered either based off of their social or their name and birthday. That generates a sheet of stickers for that individual. And on those stickers at Caldon, we labeled what we called our 3-4, which is our specific identifier and the time we drew the specimen on them.
And does it also have a number on there that indicates who drew it?
Correct. My specific number was MXO7175, and that's my specific identifier for the lab to know that I drew those results.
And whose blood? Is that the blood that you drew from Larry King on August the 5th?
Correct.
I'm sorry, August the 5th of 2019.
Yes.
And once you draw the blood, who did you give it to? A member of law enforcement?
Yes.
All right. And do you actually put it in the Ziploc bag and seal it, or do they do that, or how does that work, or y'all do that together?
I don't recall how it was done in this instance. Most of the time it's done under their supervision.
Right. And do you put the stoppers in all of the tubes?
So the tubes actually come pre-stopped. Our transfer device has a transfer needle inside of it that the blood goes directly into. We don't have any actual contact with it.
All right. Thank you, sir. Now, once you hand it over to law enforcement, or previous to you, previous to you handing over to law enforcement, did you alter it or change it or do anything to it in any way?
No, sir.
And once you handed it over to law enforcement, did you have anything else to do with it?
No, sir.
All right. I don't have any further questions. Just please answer any questions that defense has.
No questions.
Do you remember the name of the law enforcement officer that you gave this to?
I do not.
Ooh, weak link in the chain of custody right there.
Anything further?
Nothing further from the staff.
Thank you. You may step down.
Thank you.
He doesn't remember the name of the officer that he gave them to. That was the question. We've seen this before. South Carolina really hammering the chain of custody, where in other courts...
Your Honor, I did not ask this. I apologize. I asked that Mr. Stevens be excused unless defense counsel has an objection. None, Your Honor.
All witnesses are excused once they step down.
Thank you, Your Honor.
Boom, blanket ruling. We're counting objections. Because we have two defendants and they have separate counsel. We imagine there will be some quite a few objections in this trial, even if it's a short trial.
Do you affirm the testimony you have to give the court in this trial shall be the truth, so help you God? Take a seat in the witness stand. State your name again for the record. Spell your last name.
Yes, sir.
The mom is the first defendant.
Call the county
her
sheriff's
boyfriend
office.
is the second.
Deputy Barnado, did you work for the Colleton County Sheriff's Office on or about August the 5th of 2019?
Yes.
Deputy Barnado, did you have occasion to meet with Larry King on August the 5th of 2019?
Yes.
And did you take him to the Colleton County Medical Center, the Walterboro Hospital?
I did.
And was that for the purposes of a blood draw?
Yes.
And were you present when blood was drawn from him by Nurse Stevens?
Yes.
I'm going to show you, I apologize.
I heard Deputy Varnago or something like that. The Colleton County Sheriff.
Marked as 27, 28, and 33. If you would, actually first let's just start with 27 and 28. If you could Can you look at those vials? The 28's a little bit close up. Can you identify what's the vials in stage 27, 28 for identification?
Yes, this is the blood vials drawn from Mr. King.
And were you present when those vials were drawn?
Yes, I was.
And did the nurse hand those vials to you?
They did.
While they were in your custody, were they also placed in a plastic bag that's shown there in 27?
Yes.
Did you alter that or change it in any way?
I did not.
What did you do with the blood once you got it?
Once I got it from the hospital staff, I turned it over to, at the time, Detective Kelly Padgett. She was a sergeant detective with the sheriff's office.
And is it your understanding from there it went to Agent Shane?
That's correct.
Now I'm going to show you for identification stage 33. Can you identify that photograph for me?
Yes, sir. That's me holding the vials and the paperwork.
And is that, you said the vials, meaning the vials that were from drawn from Larry King?
That's correct.
It's interesting that they photographed this chain.
Representations of the vials you got. I realize there's excess writing that was already testified to,
right,
put there by Agent Shane. Other than the writing and the label, was that accurate and a fair representation of what you were handling?
Yes, sir, it is.
And is this a fair, is stage 33 a fair and accurate representation of you basically holding these bags in the hospital on August the 5th of 2019?
Yes, it is.
And again, did you alter or change anything in any way?
No, I did not.
Your Honor, at this time I'd ask that states 27, 28, and 33 be moved into evidence.
No objection, Your Honor.
You're admitted.
Thank you, Your Honor. And Mr. Hightower, if you would please go ahead and show 33. That's you holding the vials.
That's me. Yes, sir.
And then let's go 27 and then 28. And we referenced this, and I probably should have asked you this earlier. It says Larry King, and I kind of gestured over that way, but do you see Larry King that blood was drawn from in the courtroom?
Yes, I do. The beard and the white shirt.
I have nothing further. Thank you very much for answering any questions to next session.
Thank you for coming.
Yes, sir. Thank you.
Anything, Mr. Phillips?
You spoke with Mr. King?
Have I spoken with Mr. King? That day, yes.
He said that Rita would never hurt her daughter intentionally?
I'm sorry?
He said that Rita would never intentionally hurt her daughter?
He may have said that. I don't recall him exactly saying that. That's a possibility.
Anything further?
I don't have anything further, Judge.
All right, thank you.
Yes, sir.
Okay, while they're bringing up the next witness or deciding if they're going to take a lunch today.
Yes, sir. Well, we'll send you to the jury room for a few minutes. Please not.
Oh, good. So he doesn't want to approach. He's like, you guys stay away. We'll send the jury out, and then we can talk as normal. While they're doing that, just want to pop back into Weather Watch's live stream. If you want to keep an eye on this, Weather Watch has his own channel. You can we can link to it. But with exclamation point WW, we'll give you a link to Weather Watch's channel. This YouTube feed is up right now. He's monitoring the hurricane as it's moving, and it seems to keep moving a little bit left. For those that are curious and wondering what's, see if you can see my mouse on here. Can you see my mouse on the screen? It's a little small. Right here, right on the upper left corner, right by this big bend, this is where Brandy is. Brandy, that's home base. She's right there on the ocean front, right there. So keep an eye on that if you're concerned about her. She is planning to weather out the storm. Originally, it was going a little further to the right. It looks like it's moving closer to Brandy now. Way up here, this is where I am. So, there we go.
Under Rule 404B as well as 403, I believe at this point, the prejudice is manifest necessity that this is now denied Rita the right to a fair trial. This case has become about her mothering, all these other things, and not really relevant to the day. And with that, this is again evidence all about things that happened previously, not even some of them being very remote, in my opinion, and very tangentially related, other than just unduly prejudicial. From that, we believe it would be a manifest necessity based on that to move for a mistrial.
All right. Response.
Yeah, we covered all the issues as far as relevancy. I believe it was relevant testimony and her state of mind and her treatment of her child. I think is very much at issue in this case and was all relevant in testimony.
All right, deny the motion.
No mistrial.
So, scheduling wise, we've ordered lunch for the jury, and it's anticipated to be here at 12:45. So we, to the extent we can, we're going to want to go to 12:45 and then break for about an hour.
Yes, sir. Yes, sir. Thank you.
All right, so we'll take a few and let. Sir?
We're down to 10 minutes or so.
How much time do you need?
No more than 10. I can get it done in 10 minutes.
10 minutes, yes, sir.
Okay, we're going to bring the jury back in.
All rise.
For about 10 minutes, then we're going to break for lunch. This case is moving quickly. I realize they still have a medical examiner they're going to go through. That's probably going to take some time. There's probably a few more testimony. We know we've got video that we will be watching. I don't think we'll watch the entire 5-hour video, but we will be watching a substantial amount, and I'm not sure if we're going to get to see any of that or if we'll just hear the depiction of that. So I'm not sure where that stands, but that video would be the Ring doorbell camera footage that shows the mom and the boyfriend and exactly how they treated the daughter, how she was put in the car, what they were doing while she was in the car, how they then tried to open the car, and how soon they tried to take action. That'll all be captured on that camera. The jury will get to see that even if we don't. Okay, Judge Newman is fantastic. We wish we could clone him for some other trials. He did move for a mistrial, and I think this is honestly their best defense is a mistrial, which is pretty bad. They're not questioning many of the witnesses at all. They don't have any questions. Basically, the evidence is very damning. It's very bad. It makes them look really bad. And the longer they spend dwelling on it, the longer it's in the jury's mind. So they just move on, and they're going to try to address, a very few select arguments, specifically that she was a loving mother, and this, she was, distraught over the car being locked and her daughter in it, and she thought everything was okay. It was a mistake. It was, forgetful. Jury just deliberated for 15 minutes in a capital murder case in my town. Guilty, says Weather Watch. Was that the trial we wanted to watch? What trial was that? Let's see, yes, that was defense for Rita specifically that moved for a mistrial, not for the boyfriend. Why didn't they just plea? Seriously, well, first of all, I think that a plea probably was not offered in this case. The prosecution doesn't always have to put a plea bargain out there. Sometimes they will, but they did not in this one, or at least the plea that was offered probably was not very good for the defendant, and they thought they'd risk it with the jury. But these things don't sit well with juries. I'll be surprised if they get anything less than the maximum penalty. Defense has to request for the mistrial as well as objecting to things during the trial, just preserving the rights on appeal. Yes, their arguments are a little weak though, and they seem like they're trying to inflate them a little more than they should. Oh, yeah. Bad case. Hey, we just got raided by uncivil law and all his uncivilians. Welcome. Welcome. Appreciate you guys joining us. We're on break for just a couple minutes as we wait for I think we've got one more witness that'll take about 10 minutes before lunchtime starts. We're enjoying Judge Newman. Judge Newman is not having it. He's not enjoying the defense counsel in this case. He's already had some sharp words, almost instructional on a basic basic lawyering level, like lawyering 101, courtroom etiquette 101 type stuff. Denise, welcome to the gallery. Thank you so much. Love that green courthouse by your name. Appreciate your support. We love a good raid, and thank you, Uncivil Law and the Uncivilian. It's the Uncivilians. I think that's the name, right? Good to have you here. Let's see. Elizabeth, yeah, well, I guess it's not going to do any good now, but there's a long pause and you can skip ahead. You can catch up. Uncivilians for the win. Thank you, Kurt. Good to have you here. Catherine, wonderful. Glad you could join us this afternoon. Thank you very much for popping in. We're a friendly group here. We're watching a very difficult case, honestly. This is a case where the mom and the boyfriend are charged with intentionally. The state argues that they conspired to kill her daughter, who was 13 years old at the time and was disabled, is not able to speak, is not able to open doorknobs and open car doors, and they put her in the back of a car in the sun and left her there for over 5 hours, and killed her. And they're saying it was a conspiracy, and this was basically planned out, and they worked together on this. The video the neighbor took across the street, we're hearing, the Ring doorbell video shows how she was put in the car, which appears to be less than gently by the boyfriend, and then the mom and the boyfriend were like playing on the swing and just hanging out and hugging and kissing and everything in the yard while this is going on, and occasionally peering in the windows while they said they were trying to figure out how to unlock the car, which they couldn't find the fob or something. Let's see. I called them uncivies. Uncivilians, I think is the proper term, but thermostat on the wall behind the witness has been holding steady at a cool 69 degrees, in case anyone was wondering. We kept an eye on this same thermostat during the Murdaugh trial. I believe this is the same courtroom. The layout of some of the furniture has changed, especially the podium, I think. But we still have the high seat the witness sits in. It looks uncomfortable because they're balanced on this high chair, and the desk or the bar in front of them is at their knees. So it's almost way too high. You have to you can't wear a kilt and sit in that chair. I'm just saying it would not be a good look from the camera angle. Let's see. Burke Bunch, thank you very much. Welcome. I see you've got some pets in your profile pic. That's always welcome here as well. I have a sleeping dog on my left foot. It's not my dog. It's little Zoe, who's joined me today, but she's an Imperial Shih Tzu, I think. But she's a guest today. Yeah, general rules. Don't wear a kilt to court. The judge is supposed to have the most, showy clothing, and it's very bland. How can you lock a car when keys are inside? We used to be able to do that when I was, how did the car get locked is, we'll probably hear more testimony about that, possibly from the defense side. I'm not sure how they're going to bring it in, but we have heard that they supposedly discovered that she was in the car and the car was locked, and that was a problem, and they were trying to figure out how to get in the car. They didn't want to break a window because that was expensive, but they really should have done something. I can't lock my car with keys inside. I think modern cars are like that. They were in a Volkswagen Jetta, so you'd think that I don't know the year of the vehicle, but let me just out myself here. I have one set of car keys for both of my vehicles. One set of keys, and if anything goes wrong with either key, if the key breaks, if I lose it, if I lock it in the car, if that's possible, I'm out of luck. I'm calling a locksmith and going to pay like whatever they charge, because I don't have an option at that point. I know it only takes a little bit of money to get one made, but I've never made copies for my keys, and it's worked for me for years. I mean, for over 4 years for one vehicle. We just got another vehicle with just one key. That's because we buy ours used, and anyway, it's funny. I'd love to have my dog on my desk, but he's bigger than my desk. I had Zoe up on my, let me show you. I had Zoe right here, but she climbed down on my lap, and then she climbed down backwards off my off my chair, and I sort of helped her at the last minute so she didn't do the backward somersault. But I figured she didn't want to be up today. But she is sleeping on my foot, so I can't move. So the judge is to a trial. Let's see what the bride is to. What's the button? Yes, as far as the clothing, the judge in the robe, that's the one that looks fancy. That's the one that looks fancy. Of course, witnesses do get a pass, so I guess maybe you could get away with the kilt. My son wore a kilt to church like 2 weeks ago. It's funny because it's the kilt I wore at my wedding reception. I learned my lesson there. I should not have worn a kilt to my wedding reception. Mrs. R.A.'s dress should have been the center of attention, not the kilt and the fancy weaponry and everything else that I had on, and the sporran, and yeah, don't do that. Please don't wear a kilt to court. Thanks. It's on civil law. It's especially if there's a high chair that the witnesses sit on. It's like your knees are showing. I mean, there's a little joke they say in Scotland. It's not really a joke. It's a truism. They say, what do you wear underneath a kilt? And the answer is socks and shoes, like a reasonable person. But it would reveal that answer in this courtroom. Socks and shoes. That's what you wear. They are pretty nice. They're nice when there's a little breeze. But my kilt is like, it was made in Edinburgh. It's like the real thing. I think if you were to unfold and unpleat the whole thing, you could wrap the earth 3 times. I don't know how much. There's so much wool. There's so much cloth in there. But it's really good. Daughter's name is Christina, Casey. Christina was 13 years old, needed pretty much full-time care. Was able to show emotion and do a couple things. I think she had a sippy cup she was able to use herself, but due to her disability, opening a doorknob or on a house, or really preparing food for herself, which it sounds like was mostly a liquid diet. She couldn't take care of herself. She was a little bit, I guess, ambulatory, is that the word? Could move a tiny bit, but could not walk. Could sort of crawl or drag herself around using her knees and her arms a little. I'm Scottish and they wear underwear. Then you're not true Scottish, right? No, just kidding. Yes, they do. They wear something underneath. It's a commando kilt. Yeah, how do we get on this topic? Why are we talking? Oh, is it because of the witness stare? Where's the chandelier and clock? Seriously, we're missing 2 cameras. We were so used to those in the Murdaugh trial. We need the chandelier ran away with the clock. This ran away with a spoon, something like that. How much does a kilt cost? A good one can be quite expensive. The different parts, they add up very quickly. If you want to do the ghillie brogues shoes and the wool socks that go up over your calves and the little flashes and the big belt and the sporran, I had to. Since I'm no longer in possession of this, maybe I can confess, I had to smuggle my sporran in because the material it was made out of is, I guess at the time was frowned upon on importing. I'm not sure if it was actually illegal. Probably was, but it was made from real animal fur, and I guess this specific type of animal fur that is legal to make in some countries is not legal for import. That's what I hear. I've never seen the law, so I guess I could claim ignorance. I guess on the advice of my lawyer, I'm supposed to stop talking. Anyway, it's up to the individual men that go under their kilts, and I'm from Scottish. I will say, if you ever go to a Scottish festival where they do exercises, generally the acceptable underclothing for people that are going to be, throwing a caber, tossing a caber, or whatever, where you do lots of spinning and jumping. And rapid movements. Generally, we go with like a bicycle short underneath. Otherwise, it would be quite revealing every time. Let's see. What's the counter for? We're counting objections in this one because we have 2 defendants. This is a twofer, right? We've got 2 defendants in this case. They are being tried together. So this one jury is going to hear all the evidence and then decide both cases. And it's possible they might say guilty on one and not guilty on the other. I mean, they're separate. They have separate defense teams. They even have separate defenses in this case. But they're going to consider these. So it might be a long deliberation because of that, or at least longer. A lot of us imagine that it could be pretty quick based on what we think right now. But Evangeline says she's headed to Edinburgh, Scotland in 2 days. Beyond excited. That is wonderful. I've only seen it in pictures. I should go. 7 is 8. 7 is 8 months, I should say. 7 has been with us for 8 months. Thank you very much. Another great month with Dwayne. That's an inside joke for those that don't know. I'm on some calling list where spam people call me and say my name is Dwayne. And so I pretend I'm Dwayne. Is that a crime? Probably. But I do it anyway. What are they going to do? Nothing. If you get your family name, if you get your family named Kilt, it's a fortune. I did that. My last name is Scottish, as is my first name. It's Scott. And my middle name is actually, I could spell it for you, but it's a doozy. Nobody can pronounce it, even though it only has one Y and a K and it's a couple other things. But where was I going with this? Oh yeah, my middle name is from my great uncle who was in Scotland. Yes, I did get real animal fur. Let's see. Smuggle your what? Sorry. A sporin. It's the little man purse that's worn the front and center on a kilt. Gosh, you guys, you need to go to a Scottish Games, the Highland Games. If you haven't been, it's amazing. They basically, I guess, don't let me offend anyone in Scotland because I am Scottish and I have a great love for the culture. But imagine if you were working on a farm and all the chores of the farm were very, a lot of just repetitive, and you just decided, hey, let's make the Olympics out of our farm chores. That's what the Highland Games are.
Sir. Okay, you bring the jury.
We're bringing the jury. I see the judge has a little bit of a, is that a mustache? Let me zoom in a little bit. Looks like he's got a little bit of a mustache going. Is that, it's just the lighting, or are you guys seeing that as well? Judge is typing in chat. Please be nice to him when he types his message. Give him a second. Judge is just confirming that the bailiff went to get the jury because they're not here yet. We did this with Judge Newman in the ZA trial, and apparently he was watching. I thought it was funny for a moment, and then he did it, and then I was like, oh great, oh crap.
Next witness.
Thank you, Your Honor. State called Matthew Hogue.
Unless I've got a family member watching, and they should not out me, you guys are not going to guess my middle name. I could give you 1,000 guesses, unless you like cheat and do some sort of like deep state spying. I'm talking just like truly guess, like dictionary guess. You're not going to get it. So wrong answer is only, what's my middle name? What's the most Scottish middle name you can think of? Hamish.
State your name again for the record. Spell your last name.
My name is Matthew Hogue, Hogue.
Agent Hogue, who do you work for?
I work for SLED, South Carolina Law Enforcement Division.
And what do you do for SLED?
Currently, I'm a special agent in the Vice Unit for SLED.
And back in August of 2019, what were you doing for SLED?
I was a forensic technician in SLED's Toxicology Department.
Sir, I'm going to hand you, we'll do this in two batches. So first I'm going to hand you, these have already been entered into evidence, 29, 30, 31, and 32. I believe it is listed as SLED item number 4. So can you tell me if you recognize the items in those photographs?
Yes, I do recognize them.
And are you the one who took these pictures?
Yes, these pictures of the evidence bags and what was inside of them are pictures I took as part of my duties as a forensic technician.
So did you, upon this being logged into SLED, at some point did you open these bags to inventory or take photographs of what was inside the bag?
Yes, that's correct.
And did you alter them or change them in any way?
No, I did not.
And once you were done with taking these photographs, did you perform yourself as a technician? Did you perform any tests on them?
No, I resealed them and they were stored in our refrigerator until further testing by someone else.
I'm going to ask you the same thing for states 25, 6, 7, and 8. And I believe that is SLED item 6.
This witness also acts as a hair model for Lego.
Yeah, same question. Do you recognize the blood vials in those photographs?
Yes, I do.
And are you the one that took these photographs to document them with SLED evidence?
Yes, I did.
And did you alter them or change them in any way?
No.
And other than to open up the bag and catalog it and reseal it, did you have anything to do with them beyond that?
No, I did not.
Lots of good guesses on the middle name. No one's come close yet.
And I will also ask you, if you can, as to SLED item 6, can you, by looking at the listing on the vials, can you tell me whose blood sample that is?
The blood vials say Larry Eugene King Jr.
And as to SLED item number 4, I'd ask you the same question.
Rita Marie Pangalangan.
Thank you, sir. I don't have any further questions. Please answer any questions that the defense has.
Thank you.
They say, any questions the defense has? None. Thanks for coming. I thought the prosecution had turned up the heat. They've turned it up to 70 degrees in the courtroom. If somebody could please tell the last witness, Mr. Hogue, that the pin was on the wrong side, which makes him an enemy of SLED, not part of SLED. So I've said it starts with a K. Okay, we see this a lot when there's a very interesting defense, when the defense is not trying to argue the facts of the case, but more of the analysis of the situation. I think that's what they're going to do. Thank you, Thomas. I think you know it as well.
You affirm the testimony about to give before this trial shall be the truth, so help you God. Yes. Take a seat on the witness stand. State your name again for the record. Spell your last name.
My name is Brooklyn Molina. My last name is Molina.
And I messed that up and said Brooklyn Gonzalez. I had both names written down. I'm sorry, I can't remember one. So your married name now is Brooklyn Molina?
Yes, that's correct.
Agent Molina, who do you work for?
I'm employed by the South Carolina Law Enforcement Division, commonly known as SLED.
And what do you do for SLED?
I am a forensic toxicologist in our toxicology department.
I'm going to hand you a couple sets of photographs that have been testified to and are already in evidence. So I'd like to start with what is referred to as SLED item number 4.
Weather watch.
Which is a collection of 4 photographs, 29, State's Exhibits 29, 30, 31, and 32. If you would look at those and let me know, did you have anything to do with the blood vials of Rita Pangland in SLED item 4?
Good guess, but
I would have assisted in taking these photos.
You actually assisted, is that Mr. Agent Hogue?
Yes, Matthew Hogue.
And there's a yellow sticker, and I think this was testified to earlier. There's a yellow sticker on those. Mr. Hightower, screen 25, please. So this yellow sticker, can you tell me what that yellow sticker signifies?
Yes, that is the unique SLED identification number that was given to this case, and number 6 represents item number 6 that was submitted to us.
So if I could borrow those real quick, Mr. Hightower, would you please bring up 29? So is that what I was just referring to as SLED item number 4?
Yes.
Blood from Rita Pangland, and would you tell me about SLED item number 6, whose blood that is?
These vials are labeled King, Larry Eugene Jr.
And did you perform any, you said you assisted in taking the pictures, did you do anything else with SLED item 4 and SLED item 6, the blood vials from the defendants?
Yes, I performed the blood alcohol analysis as well as the preliminary drug screen.
All right, and your blood alcohol analysis, is that like ethanol? Or?
Yes.
And did you find any ethanol, and we'll just do it one at a time, in SLED item 4, which is Rita Pangland's blood?
No.
And did you find any ethanol for SLED item 6, Mr. King's blood?
No.
You said you did a preliminary, what was the?
A preliminary drug screen.
And let me ask you this. As part of your job at SLED and what you do at SLED, what kind of qualifications and things do you have to have to have the job that you currently have at SLED?
So education-wise, I have a Bachelor of Science in Forensic Chemistry from Ohio University, and I have a Master of Science from the University of Florida in Forensic Toxicology. Education aside, we undergo extensive in-house training for blood volatiles analysis that consists of analyzing 500 previously analyzed samples and comparing those to the known values, as well as completing, we had multiple lectures, each followed by an exam and then a comprehensive exam. We are competency tested, which is an internal test to determine if we are competent in that analysis. And then we are proficiency tested each year by an external vendor in each discipline that we're deemed competent in. For drug screens, my training consisted of assisting in 100 case samples and the operation of the instrument. Again, we were competency tested and are proficiency tested by an external vendor each year with that.
And just, not about this case specifically, but this case and other cases you would do, what is the procedure of that you follow once you do your preliminary tox screen? If it's positive, what would you do with it?
So once a case is positive on our preliminary drug screen, those results all have to be confirmed, so they are then assigned to another analyst in our lab.
And does that let me back up for a second. So you talked about your undergrad degree is in, what is it?
Forensic chemistry.
All right. And how long have you worked for SLED?
I have worked for SLED approximately 5 years.
And you said you talked about some proficiency exams. How often do you have to do those?
Yearly.
So have you passed them every year?
Yes.
Have you ever been qualified as an expert before?
One time.
And what would your expertise be in if I was to ask the court now to have you declared as an expert in? Would it be forensic toxicology?
Correct.
Your Honor, at this time I'd ask that Agent Molina be qualified as an expert in forensic toxicology.
Says the defense.
I think she's an expert. Just subject to the prior pretrial.
All right, she's so qualified.
Thank you, Your Honor. Ma'am, we talked about doing different tests, the fact that you did a preliminary toxicology. So if we could just take them one at a time. As to SLED, and I'm going to make sure I get this right, as to SLED item 4, which is the blood of Rita Pangalangan, were you able to run a preliminary toxicology screen on that?
Yes, I completed a preliminary drug screen.
I'm sorry, I used the wrong language. A preliminary drug screen.
Correct.
Did you get a preliminary hit on any drugs?
Yes, that item number screened positive for methamphetamine and amphetamine.
And ladies and gentlemen, once a witness is qualified as an expert witness, they're then allowed to offer opinions in the area of their expertise subject to the rules of evidence.
Thank you, Your Honor. As to SLED item 6, Agent Molina, were you able to, or did you run a drug screen on that?
Yes, I did.
And that's the blood of Larry King. What results did you get as far as a preliminary?
This is the important part.
Do you have a copy of the report, actually? I just want to make sure I tell you the correct.
This is only her second time testifying as expert witness. She doesn't remember off the top of her head. That's all right. She is allowed to reflect on her notes to get it right. You guys can stop guessing. No one has gotten it yet.
Just after reviewing that, see if that was correct.
Yes, so I did perform a preliminary drug screen, and that would have been positive again for methamphetamine and amphetamine.
So both had a preliminary result of methamphetamine and amphetamine.
Correct.
And
there's the boyfriend.
What did you say the procedure was once you do that?
Then that case is assigned to an analyst to confirm those results.
And who would the analyst be in this case?
Lindsay Mitchell.
And other than what you testified to, did you have anything else to do with this case?
No, I did not.
All right, thank you very much, ma'am. I have no further questions for you. Please answer any questions the defense has.
Thank you.
From the defense.
So I think I understand the process. You say you do a preliminary screen. I assume if it's negative, then that substance is discarded. That's the end of the investigation into that substance. Is that right?
For that substance, correct.
And then you said it's positive and it's sent to someone else for a confirmation.
Correct.
Is that right? My question is, when it goes to someone else, is that like a higher echelon of testing? Is that something that is more specific? Or is it someone else who is, if you will, on your same level within SLED, we all just check behind each other?
No, so it would go to confirmatory testing, which is going to go to a class-specific confirmation.
Okay, and would it be fair it's just a higher level of testing?
Yes.
In a layman's?
Yes.
Thank you. Thank you, Ron.
No questions? Virtually no questions.
Good afternoon. Based on your training experience, you can't tell when a substance was ingested, right?
No.
And so that preliminary report, it could have happened several days before the blood was actually taken. Is that fair to say?
Well, if it's in the bloodstream currently, it is acting on the individual.
Well, now, as far as your expertise, your training and experience, I want you to go outside the scope of what you have.
I'll tell you after the break.
Whether somebody tests positive, they could have ingested it days before and still test positive. That's true.
Yeah.
Because you can't tell from the preliminary report when somebody may have ingested a substance.
Right, just what is currently in the bloodstream.
Thank you. No further questions.
Anything further?
Nothing further. Ask that she be excused.
All right. Now, every witness is excused once they step in. And you're excused.
State calls Lindsay Mitchell.
Thought they were going to have a break here for lunch. Maybe not. You guys, you've got some great name guesses. You're guessing my middle name. No one has come close yet, other than that starts with a K. And Weather Watch gave away too much information already. Weather Watch gave you 3 letters, and some people have at least used the 3 letters creatively, but that's about it.
State your name again for the record. Spell your last name.
My name is Lindsay Mitchell, Mitchell.
Agent Mitchell, who do you work for?
I work for the South Carolina Law Enforcement Division.
And did you work for, is that also commonly known as SLED?
Yes.
Did you also work for SLED back in August of 2019?
Yes, I did.
These are already in evidence and been testified to, but let me just call out. As to SLED lab number 19-14197, items number 4 and 6, did you perform any, well, let me back up for a second. Did you have anything to do with those items or analysis on those items?
Yes, we performed testing on these evidence items.
There was earlier testimony, ma'am, from Ms. Molina dealing with kind of what a preliminary tox screen is. Can you kind of describe the process of what occurs when there is a positive, for lack of a better word, positive hit on a drug screen?
Yeah, if our drug screen results in a preliminary positive, that has to be confirmed by another type of analysis before we can report it.
So let me ask you a little bit about your background. What are you, is forensic toxicologist the right word?
Yes.
So to be a forensic toxicologist, what kind of undergrad degree or training education do you have?
I have a double major bachelor's in forensic science and chemistry from Pace University. I also have a master's in professional studies from the Pennsylvania State University.
And what sort of, and I may have asked you this already and I apologize if I did, how long have you been with SLED?
For 8 years now.
So did you have any job in forensics or chemical analysis prior to working for SLED?
No.
We have a winner.
You've been there now 8 years.
Yes.
So tell me a little bit about the certification process. What do you have to do, or what types of certifications do you have to go through, or testing to maintain your job as a forensic toxicologist?
We undergo extensive in-house training for blood alcohols and for drugs for analysis and interpretation. We have lectures and hands-on training that we do. We have to previously analyze samples before we can take a competency test, which is supposed to mimic a real-life case sample. We also do oral training, like mock courts and stuff like that, before we're signed off and deemed competent. Since that time, we have the opportunity to do extra training, extra courses that we get to go to, such as the Borkenstein alcohol course, as well as they have a Borkenstein drug course. And we annually do proficiency tests in all of the subjects that we perform analysis in.
And you said annually, so you have to do that every year then?
Yes.
And have you failed any of those proficiency exams?
No.
How many samples do you think, including all these, the testing that you did as well as actual cases, how many analyses, I guess would be the plural of that, how many times have you looked at this kind of stuff?
Probably into the thousands.
Have you ever been declared an expert in the state of South Carolina or in federal court?
Yes, I have.
How many times?
Probably about 4 or 5.
Your Honor, at this time I'd ask that Agent Mitchell be declared an expert in forensic toxicology.
No objection, Your Honor. No objection to qualifications, new prior objection regarding toxicology.
She's so qualified.
Thank you, Your Honor. Agent Mitchell, in this case, and obviously I've already referenced the lab number, there was testimony earlier from Agent Molina that a preliminary tox screen was done and it was positive for methamphetamine and amphetamine. Was that sent to you for confirmatory testing?
Yes, it was.
And was that confirmatory testing done?
Yes.
And can you just kind of explain the process of how that works?
So a sample is taken from the evidence. It is run on a GCMS, that's gas chromatograph mass spectrometer. That instrument gives us the ability to separate and identify things that might be in that sample. So in this case, it was run on a specific test for sympathomimetic amines, which is the drug class that includes methamphetamine and amphetamine.
And let me ask this, it was asked earlier, this is like, would you call this a higher level of testing or just a more specific testing?
I guess both. It is more specific, but it also gives us a quantitative value as well as the confirmation of the presence.
And were you able to analyze that information on, and I'm sorry, I didn't forget, but if I try to pronounce it, I'll mess it up. What's the machine that you guys use again?
GCMS is the easier term.
So on the GCMS, were you able to analyze this?
Yes.
All right, so as to SLED item number 4, which is the blood of Rita Pangalangan, were you able to reach a confirmatory analysis?
We did, yes.
And what was that confirmation?
I know that it confirmed for the methamphetamine and the
Did you do a report on that?
Yes.
All right, I'm going to hand you what's been marked as State's Exhibit 15 for identification. Can you identify that?
Yes, this is my report.
And is that your name that appears on the bottom?
Yes.
Of the second page, I believe?
Yes.
All right, and if you'll go to the second page, what are your results as to Rita Pangalangan's SLED item 4?
We found methamphetamine at a level of 400 nanograms per mil, as well as amphetamine at a level of 160 nanograms per mil.
And is that report an accurate reflection of your results?
Yes.
Other than that I stapled it, has it been altered or changed in any way?
No.
Judge, I'd ask that State's Exhibit 15 be entered into evidence.
Save defense.
The document still says hearsay. It can be referenced and it's now been testified to in the record. And it's subject to the fire pre-trial with the document still.
Any response?
Judge, I apologize for you asking.
Yes, sir.
Yes, sir. It's not a hearsay document. The agent who wrote it is here to testify. If she wasn't here to testify, then it would be a hearsay document.
The document itself is cumulative to the testimony, so the objection sustained.
Wow. First sustained.
I'm going to hand you what's been marked as State's Exhibit 14. Is that also the report that, in this case?
Yes.
And what SLED item number is that in reference to?
Item number 6.
And as to SLED item number 6, were you able to reach the same conclusion as to levels?
For levels, methamphetamine was reported at 480 nanograms per mil and amphetamine at 88 nanograms per mil.
And who is that in reference to, that SLED item number?
Larry Eugene King Jr.
And were those, is that a correct and accurate reflection of your results?
Yes.
Your Honor, the court's indulgent, please.
I thought we were going to take a lunch. Did you guys hear the judge say we were going to take lunch? He gives us an hour. It's not like some of these other states that get like an hour 15, hour 30.
So, a couple other questions. There was a question earlier about if that was in the blood. If you see amphetamine and methamphetamine both, can you explain to the jury what a metabolite is?
Sure. So when you consume some type of drug, your body can break it down further into what we will call a metabolite.
All right, and so can you answer the question as to this case? Is amphetamine a metabolite of methamphetamine?
Yeah. So in this case, when someone consumes methamphetamine, it is broken down to amphetamine in the body.
So is that a natural body process as the body is processing the methamphetamine, and they convert some of that into amphetamine.
Yes.
And if someone has these sorts of levels, and if you need this, I can give it back to you, but I think your testimony was in excess of, I think, for Rita Panglangan, it was 400 nanograms per milliliter of methamphetamine, and for Larry King, it was 480 nanograms per milliliter of methamphetamine. Can you tell me anything about how that would act on the body?
Yeah, so methamphetamine in general, some of the physical side effects you could have are rapid or irregular heartbeat, labored, or not labored breathing, but irregular breathing. You could experience agitation, anxiety, confusion, euphoria. It's different person to person, but those are the general effects that you might see.
And at that level, would you consider that person to be under the influence of methamphetamine?
To some extent, yes.
I don't have any further questions. Please answer your questions if Vince has.
This is South Carolina.
Good afternoon.
Good afternoon.
Just want to make sure, through the metabolites, as far as you testified, you're not able to tell when the substance was ingested.
Correct.
And it could have been ingested up to, specifically with methamphetamine, up to 3 days prior to when the sample was taken, generally?
Yeah, probably, possibly.
And a higher threshold was taken 500, right? That would be a greater indicator that it was taken within that 3-day period?
No, I wouldn't necessarily say that just seeing greater than 500 nanograms per milliliter indicates that it was taken.
As far as the literature that's out there?
Not that I'm aware of.
But you do agree it could have been ingested up to 3 days prior. There's no way for you to know.
Yes, that would be possible.
Thank you. No further questions.
Anything further?
One question, Judge. Ma'am, is there any question, though, that the body is still acting on the body at that time?
Yeah, the fact that it is in the blood shows that it was active in the bloodstream and in the body at the time of the test, the time of the blood draw.
Thank you.
In the ping pong, but you don't know how it would affect that person specifically. You're saying it's active in the blood, but you don't know how it's affecting that person in any way, shape, or form. You can't testify to that.
To like what specific effects they might have been feeling at that time? No, not specifically.
Right, because they might have done it 3 days prior.
Correct.
Thank you.
All right, you may sit down. Hey, ladies and gentlemen, we're going to break for lunch now. We'll start back at 2:15. Please go to the jury room and please not discuss the case.
We get 1 hour and 10-minute lunch break. Let's see if there's anything they need to address once the jury has left. I don't think they will. Let's give it just a minute to see. Good, I'm hungry. Yes. Good job on choosing finding my middle name. Was it a true guess, or did someone just do some next level, deep state investigation? Back at 2:15. So it is 1:05 right now in North Carolina. Isn't it even worse if they were sober? This is not a win-win. The argument he was fighting about how much drugs they were doing, I guess it would look worse if they were doing meth while she was in the car. I guess that's what his thought was. I already ate one of my jars of pickles, and I only have one more jar of pickles left. And I can't eat 2 jars of pickles in the same day, because although I love them with all my heart, and they're delicious, and I'm grateful that they're in my life, 2 jars of pickles is too many in one day. Yeah, Stephen. Okay, wrong answer is only, no, let's not do that. Let's not do that. Judge brings lunch in so the jury doesn't waste time going out for it. I like to see courts that value the jury's time and the fact that they're also shelling out of pocket a lot of times to park to get lunch and things. I like that when the court covers that for them. Mrs. R.A. was going to talk to you if you have 2 jars. She does not like the pickles. I still like her, but she does not like spicy maple bourbon pickles, which I still don't understand, but I will accept because I like her. She's really nice. Lots of other things, Liven, that we're not going to guess. Let's see. He's the best when it comes to jurors. I love his approach for the jurors. His concern for the jury, honestly, his concern for their time is like foremost. He's like a very patient man. He's sat through some long things, but he understands that juries, they're taking time out of their life. He's getting paid to do it. He understands the jury is being legally required to be present, and generally not by choice. Some of them would do it even if they're given the opportunity, but he's very mindful of that, and he expects the lawyers in his courtroom to be mindful of the jurors as well and respect them. My daughter drinks pickle juice after she eats the pickles. That's okay, but in this one, it's like the whole Jose Cuervo thing, the worm at the end. No, you don't eat the chili pepper in these pickles after you're done. It's just raw heat and not good flavor. They call that respect. Yes, he has that. Why would you bring that up, Nurse for God? Just kidding. Can I die from drinking pickle juice? I like to drink the pickle juice, just not like large amounts of it. Thank you, Casey. Appreciate it. Proper mushy peas. I'll eat them. It's not high on my list. I prefer just like cooked. I'll eat peas raw, like snow peas, straight out of the pod, out of the garden. Pick them and eat them. Great, good stuff. Mushy peas, my least favorite form. Or split. Split is actually worse than mushy. How many pickles in a jar? Now, not very many. So, all right, we need to go to lunch. I didn't say the pronunciation. Kynoch was the proper spelling, and Kynoch would be the official pronunciation. Although in the United States, it's commonly just referred to as Kinnick. So there you go. Just ask Ivan about eating hot pepper. Yeah, we'll do that. All right, we are going to take a break. We were not. I'll say this again. I apologize. We were not planning on covering this trial. We had other trials lined up. First, yesterday, one fell through in Bexar County. I worked with the court, worked with a couple media outlets there, trying to get that working, and it was just a no-go on that one. So we had to bail on that one. And then today, the court from Wisconsin let us know that the option we had been pursuing and preparing for there was not working either. So we ended up going back to this one, which we talked about a couple days ago about covering this, and had looked at and said maybe. And I wanted to do something else because obviously it has a child victim, which is a very, very tough and a victim that was not able. Sorry, who triggered that? Was not able to defend herself and or even fend for herself in this case. So it's just a tough one that way. But I appreciate all you guys being here and helping us get through this tough case. And thanks for all the wonderful guesses on the middle names. They're all good names, all good guesses. Pickle juice, not basically vinegar. If you go with the dill, it is more vinegar, but these are more of a bread and butter, which is a little different makeup. So it's a sweeter juice. All right, that's it. I'm going to take a break. We're going to be back at 2 o'clock for the afternoon session. We are still keeping our eye to the ground to see if there's some other cases coming up. We're going to try to bring you the best one all the time. So we thought we had a scoop on a good one today, and it ended up falling through. So we'll go back. Yes, we are coming back. We'll come back this afternoon because we're on an East Coast trial. It's going to end a little bit early. Just a quick word. Let me just see. Weather Watch still has his channel up right now, showing the hurricane path. It's looking like it's hitting right in the middle of that bend. So, and then it's going to go across the country, Florida, Georgia, South Carolina, and then it's going to come to my house. So that'll be exciting. Wednesday night, Thursday morning-ish. We'll see how that happens. So could be a fun day. Rain delays likely. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again at 2 o'clock. 2 o'clock, we got 45 minutes or so. We'll see you there. Thanks all.
Scratch all that. Oh, that was terrible. I apologize.